national capacity for data protection, so that organizations such as our own university, such as the judiciary, can be positioned to deliver on the promises and the prospects of the legislation, which is protection of rights of persons and, of course, all other issues related there too, where persons include not just the individual, but also organizations. So we got done with that, and then we realized that, okay, we do have a challenge. Sometimes the process of formalizing the introduction of a new course, whether within an existing degree program or howsoever, can be pretty elongated. And so we thought, why not start a Moot Court competition that enables interested students, and we are starting with law students because it's a court, you know, but we are hoping that over time, within the whole system, we can have other stakeholders support the law students, maybe with research, with data, because data protection is not just about what we do in court. That we are hoping that we don't get to court, because if we get everything right, we will not then need to get to court to get redress, you know, and we will not be bothering the docket of my lord. So this is what we have been doing, and we had a small event last year, and it was such a huge success, and we're here again today. I have received feedback on what it is that I wasn't able to stay to the end, even though I started, but even non-law students who were here yesterday gave me feedback about how it was an eye-opener. The words that one of them used was that there's so much knowledge out there that I didn't know about, such body of knowledge, and it was good to have that opportunity. So I will say to other students who are here, bring out your phones, tell your friends to join us online or come in here physically, because there is a body of knowledge to gather from here. And like I said to those who were here yesterday, this will be a nice opportunity for those who have nothing, who've never been in the courts, to get a glimpse of what it is that we do in the courts, a little glimpse of what it is that we do, even in the national courts, but more of what we do in the international courts is what it is that we're going to be doing here. This is a simulation of what happens real time. So on behalf of the Vice Chancellor, Professor Folashade Ogunshola, I want to warmly welcome you. I want to thank the Faculty of Law, and that indirectly thanking myself. I want to thank the Faculty of Law for this initiative, which helps us to be able to qualitatively enhance the learning, teaching and learning, even research capacity development that we are delivering. The whole idea is that you learn in and out of class. For the law faculty, mooting is a requirement for accreditation. It didn't used to be, but it is now, because the idea is that law students must be able to apply their trade in practice even before they graduate. So we expect that this, unfortunately, the Dean of Law is here. The Dean of Law, just as we challenge the students in the creative arts to give us, say, monthly performances, we are hopeful that the Moot Court will soon be, the moots in Faculty of Law will go beyond the data protection moot, and very soon we will be able to come into the faculty at the minimum once a quarter, you know, to observe. And when I mean coming, it does not have to be in the physical, because I know that we have all the gadget that enables joining such sessions virtually, that once a quarter, we will be able to see our students in action, taking on topical issues. And through that way, they will not only learn for themselves, through their work, they also will contribute to the development of jurisprudence. I want to warmly welcome you and thank you for coming. Thank you.
Ladies and gentlemen, if that warming clapping is for the Deputy DVC, development services. You can do better. Put your hands together for her, please. Like she says, it's endowment of many things we need to pick from here. She says hashtag or record and inform your friends that something else is happening here today. You know, not to bother more on this, I'll be bringing the Dean of Law himself and person of Professor Ige Bolio Deoku to give us a welcome address for this occasion. Put your hands together for him as he's coming, please. Thank you.
Thank you. Let me also stand here. The DVC, our distinguished guest, the Director General of Nigeria Data Protection Commission, distinguished panel of judges, contestants, ladies and gentlemen. Let me say that I'm particularly happy that we are doing this again. I'm the second version of this. I was with it the first time we did it. And the doing of it really, for me, helps to advance the knowledge that we need to have on data issues, their protection, and the enforcement of their violations. I want us to also note that this learning, this exposure is imperative for our students, for the general public. And again, for the fact that before now, the idea of enforcement of right to privacy was virtually limited to just the person, physical. But as we know today, our lives have changed because of technology. There's so many activities going on in the virtual world. There's so many transactions that are occurring. Even as a country, we have turned into a data collection country because so many institutions, so many organizations, are collecting our data. And because of that, the possibility that before then or before now, we couldn't steal the person as such. Of course, you can kidnap and all of that and violate this right to privacy. You can infiltrate into homes and all of that. But because we have our identity in virtual form today that can identify us and locate us as an actor in any incident, it is actually possible now to steal us through our data and then limit, if care is not taken, the enjoyment of other rights or fundamental rights that we have under the Constitution. Because if someone is able to steal your data that can identify you as you, and then superimpose it on certain activities, if you don't have enough evidence or argumentation to disprove that it wasn't you, then you may really end up being jailed for what you really didn't know about. This is the essence of what the legislation is about, and that also underscores the value of what we are doing. That how much information do we have or knowledge of the law? It's a very new law. I know that the regulations is 2019, but the law in a comprehensive form is new. And there is the need for us to engage continually the contents of those laws. All of the nuances, in a way that they affect us, we need to engage and continue to do so until we are so conversant with it. Because it's about you, your person, your privacy. If the data that is collected from you can land into wrong hands, they could do multitude of things with it. And once they are able to do that, your person has been stolen and of course compromised your integrity. And some of them would also lead to your personal liberty being actually, tampered with. That is why I believe that we are on the right course to continue to engage this law, to continue to also foster knowledge about it and sensitize every one of us that are involved, all the stakeholders, in such a way that at the end of the day, we will turn into some activists, so to say, because the sensitization will bring about more awareness and then readiness for us to protect, our own data and our privacy. And on that note, I want to thank the organizers. I know that, they are from from my faculty. But the fact that they are doing this again means that they are very committed to this, to advance this knowledge. And I'm sure that it's not going to end with this one. And as the DVC had noted, we will move the meeting to other areas of activities in the faculty that could also advance knowledge in this community at least, and for the general public. Thank you very, very much for coming.
Thank you so much for that welcome address. It is on this note, ladies and gentlemen, we're going to be taking one or two comments from a brief remark by Mr. Vincent Olatunji, the National Commissioner, Nigerian Data Protection Commission, is ably represented by Babatunde Bamboye. A round of applause for him. Is going to be listen to him via the line. Thank you. Mr. Babatunde, sir, over to you for your brief remark for today. Thank you, sir.
Thank you. Thank you very much. Let me go off camera because of the bandwidth. I don't know, maybe I'm clear over there because I lost you a while. Maybe
you're very clear. You're very clear from this.
Can you hear me?
Yeah, we can hear you very, very clear.
Hello.
Yeah, we can hear you very, very clear.
I'm all right, great. But I'll be off camera so as to make it clearer. Good morning to the Professor Ayo, the Deputy Vice Chancellor, the Dean, and my Lord, I understand that we have a judge in the meeting, right? Good morning, and to the students and the organizers. We bring you good tidings from the National Commissioner of the Nigeria Data Protection Commission, Dr. Vincent Olatunji, who would have loved to be part of this event today, but for some other assignments, he couldn't, and I'm to represent him. Having said that, we are always excited to be part of initiatives such as this, not only because, not least because it represents a key factor in the advancement of data privacy and protection in Nigeria, that is awareness. Awareness, I think you will agree with me, is the first line of defense that we have against violation of our rights. We can only protect what we know of. And happily, opportunities such as this seek to promote that awareness, even in the university community, amongst those that are coming in. But I want us to look at this a little more closely by way of a SWOT analysis, the opportunities, the strength, the weakness, as well as the threats there is in the ecosystem. For lawyers, yes, of course, we are talking in terms of regulations, we are talking in terms of law. Therefore, the lawyers are really the best equipped in explaining the law and seeing how to guide people, seeing to the guidance of people towards being on the right side of the law. However, the weakness in this process is that lawyers are really very conservative in thinking, including when I say lawyers, I also respectfully mean the jurists and the judges, as the case may be, even professors in the university. We may tend to be quite conservative in an ecosystem that is really disruptive. They keep changing. If we become too conservative about all of this, then we may lose a lot in the ecosystem. But the opportunities, no doubt, they are there for all of us. I recall when I was in the university, I never had the opportunity that you are having today to interrogate data protection, to interrogate what we now know as digital rights in general, or ICT law, even broadly speaking. But today, students do have that opportunity to look at all of this. And it has been said that data is the new oil. In other words, if you want to come out there to be to participate in the in thing, the trending thing in the market space, it has to be something that you are doing. There's something around the use of data or the protection of data, as the case may be. However, there is a threat, and the threat is that other professionals are coming in, even to do the work of lawyers. You can imagine things as simple as service level agreements, when we know very well that lawyers, this is our domain, that is drafting agreements and all of those. But because lawyers do not even know, I mean, in large degree, do not really know what data protection is about, what ICT really is about, it becomes difficult for them to put an agreement together in terms of data protection. So it's important for us to recognize that there are people who will come into the field and take up responsibilities that ordinarily lawyers should have taken up by virtue of their training. And that is why we want to commend the organizers for starting out. We can see this as maybe something like a Catch Them Young initiative, that we allow, that we give the opportunity to students to learn quite early in their career what data protection is all about, what data economy or digital economy is all about. Apart from all of this, thankfully also you now have an act which brings certainty into the ecosystem. It is unlike those days where you don't even have the act. You have to rely on court decisions explaining privacy or trying to expand what privacy is under Section 37 of the Constitution. And until the NDPR came in 2019, but you are fortunate now that you have an act that is a lot more comprehensive and with a greater force. And also you have the commission in place that we constantly come up with frameworks that we guide the system. At the moment, the commission is working on the General Application and Implementation Directive, which is a committee. There is a committee on that, which I chair. And this will further eliminate gray areas of the Act and provide guidance even on some other novel issues that are coming up in the ecosystem. We're there on behalf of the National Commission, National Commissioner, and the Commission as a whole, urge every participant to pay attention to it. 5 years ago, I never thought I would be a data protection lawyer, strictly speaking. But today, that is where I am. And I can see so many lawyers, developing core competence in this area. They have left the traditional way of practice and now focusing on, innovation. So it is going to be an exciting opportunity for you out there if you choose data protection as a practice area in law. With that, we look forward to this to successful competition among the contestants. Thank you.
Okay, distinguished ladies and gentlemen, your hands are not too busy. A round of applause for Mr. Babatunde Bamboye. Is actually representing the Commissioner, National Nigerian Data Protection Commission. Put your hands together for Mr. Babatunde. Also, we'll continue. There's going to be another live we're going to be on to Dr. Ololade Shilon. I want to tell you that Dr. Ololade Shilon is the head of Private Policy Africa, Middle East, and Turkey. If he's live with us, we'll love to have his wonderful remark to this wonderful program, please. If Mr. Ololade Shilon, are you live with us?
Dr.
Yes, I am.
Ololade Shilo, and she's female. Ololade, are you online? I can see you
Yes, I
online.
am.
Kindly on mute.
Can you hear me? I'm
Yeah.
online speaking.
Yeah, great.
Okay.
We can hear you clearly. Go ahead, please. Can you put on your camera? Let's see, it's been a while.
Let me know if you can see me. Can you see me now?
Oh, great, fantastic. We can see you now. Thank you very much for coming on. Let's have your brief remarks, please. Thank you.
Okay. Do I go first or does Mr. Bangwe
Oh,
go
it's
first?
your turn now. Go ahead.
Oh, okay. Thank you very much. A good, I think it's morning. I think it's morning for us in Lagos. Good morning, everyone. My name is Ololade Shilon. And has already been said, I'm the head of privacy policy at Meta. I cover Africa, the Middle East, and Turkey. So first of all, let me apologize for not being able to be there in person. I really wanted to, and I tried my very best to be there in person, but it just wasn't possible. So that's the first thing I wanted to say. But it's really a pleasure and an honor to be joining you virtually today for the second iteration of the University of Lagos annual Moot Court competition. As you will know, we're partnering with the University of Lagos Faculty of Law to support this initiative. For the second time, we also partnered for the first iteration around this time last year. And I just want to sort of share why, which I think maybe some people might be wondering, like, why does Meta care about, supporting a Moot Court competition on data protection? I think the simple reason is that we care about ensuring that we're able to foster, a robust data protection ecosystem within Nigeria. And one of the ways, this is just one of the, I will say, small ways in which we believe we can support in this regard. Because as a Nigerian and also a lawyer who studied in Nigeria, I'm aware that data protection, I don't know about now, or at the time I was studying a couple of years ago, was not necessarily a subject that we engaged in. And so one of the ways we thought we could sort of encourage this to be more, an issue that is talked about, in institutions of higher learning is to support this kind of initiative. So that's one of the, that's the main reason why we're doing this. Because at the end of the day, it's important to have a thriving ecosystem. And because data protection really it's not necessarily an issue for lawyers, but we feel that that's just a starting point. That if we get lawyers, or those training to be lawyers to understand and to be able to engage at this early stage on data protection issues, it helps to shape their thinking and also might encourage them to take, career paths that pursue this issue, or even if it doesn't lead to them taking a career path, but at least they have this background knowledge in all they do. And in any case, data protection is a cross-cutting issue in terms of the legal profession. So that's the reason really why we're supporting this initiative. I'm aware this is only the finals, and so there have been several rounds. And I just want to say thank you to the University of Lagos, the Faculty of Law, for being a very good partner in this, for really taking, all the efforts to make sure that this has been a robust and a quality competition thus far. And I'm really looking forward to listening to the final round and engaging as much as possible. So thank you very much again for the opportunity to be part of this Moot Court, and I'm looking forward to the engagement. Thank you very much.
Thank you so much, Dr. Ololade, for that wonderful remark for today. Please, a round of applause for her, please. It is on this note that I want to bring before the podium this wonderful day, Dr. Akintayo, to actually introduce the finalists and also give us brief about how the judges' stand is going to be for today. Put your hands together for Dr. Akintayo as he takes this wonderful task before him this day. If you're clapping for him, you can do better, please.
You don't clap for me very well. You not get lunch. All right. Thank you very much for that, Malam. Now, it's my brief to introduce the finalists as well as our judges to the table. However, before I do that, I think I should give a very brief background of how we have arrived where we are today. Like the DVC said, and like Lolade also repeated, this is the second edition of this National Moot Court competition. I started last year. Around this time last year, we had the first edition. This second edition started with 17 universities across Nigeria registering to participate. Out of those 17 universities, 8 qualified for the quarterfinals through during the preliminary rounds through the submission of briefs and assessment of the briefs. Out of those 8 universities that participated in the quarterfinals, 4 qualified for the semifinals, which was held virtually. Yesterday, we had the semifinals between the 4 top schools, and 2 universities have qualified for this final round. And the 2 universities are Team 16, Wale, Team 16. Team 16, we have anonymized the names of the universities for quality control purposes. And this is data protection. This is about privacy. So we have anonymized the universities, and the names of the university will not be unveiled until the last moment. So for now, we will stick with the team numbers. So this is Team 16. Team 16 is represented by Adedayo Michael. Stand up and take a bow. And then Tiwalade Adekile. Team 16 will be going against Team 22. Team 22 is represented by Inuoluwa Olaposi. He likes to stress that his name, Inuoluwa Olaposi. And then there is Samuel Oluduro. Samuel Oluduro. So those are our contestants today. Those are the 2 teams that will be slugging it out. For our judges, we have high caliber member of the panel, just like last year. The first person I want to call to the table, high table, or maybe I should call it equal table because this one is not high. That I want to call to the table is my Lord, Justice Rahman Oshodi of the High Court of Lagos State. Milo was also with us last year. Can you appreciate him more, please? Anytime we call upon him, he's always obliging us and answering. We are really very grateful, sir. Thank you very much, sir. I also want to call to the table somebody I always refer to as a small woman with a very big portfolio, and that is Mrs. Celestina Nwabwese. Celestina Nwabwese is from the law firm of Olaniwon Ajayi. But the big thing there is she is one of those that drafted the act that we are using at present, the National Data Protection Act. So you can see why I said she's a small woman with a very big portfolio. And then we have Mr. Sadiq Bello in the house also. Mr. Sodi Bello is a professional in the field. Not only that he has all the formal qualifications on privacy and data protection, he's also somebody who is actually a practitioner who is applying that knowledge in the field. So Mr. Sodi Bello also was with us last year. In fact, he was with us during the quarterfinals as well. So please, another round of applause for him. Also, Dr. Babatunde Bangboye also will be, watching the match and assessing the team. They all give their suggestions and contributions at the end of the match. Dr. Ololade Shilon, who is the head privacy policy at MECHA, is also one of the judges. So, but both of them are online.
Dr. Akitayo.
Yes, sir.
Thank you. I wish the University of Lagos can dash me a doctoral degree. I won't mind. but until that place, I did not have a doctoral degree.
By the authority conferred on me.
Yes, so for this.
As a doctor myself, I now confer upon you honorary doctorate degree of data protection.
Thank you very much. I appreciate.
Thank you very much, sir. So those are our judges and those are our contestants as we have introduced them. So the next item on the agenda is to go into the moot proper, to go into the arguments proper. Team 22 will be the applicant. They will be arguing the applicant case, while team 16 will be the respondent, like we have said. So, Malam, please come and give us some tidbits while I do some house cleaning.
Okay. Ladies and gentlemen, put hands together for yourself. I can see some smiling face and some certain set of people. They call me Malam, and I will love to address myself. Any Malam in the house? So I happen to be the only educated Malam in here right now. Sometimes ago, it's upon us that actually let's find out that any small thing they find out, the Malam will see it the other way around. I'm not saying to just support the Malam or do something against them. It was opportunity was given to an houseman to sing a song. And it gets to a time when other languages were singing, like Igbo man, they invite him to do a song. Guess what Igbo man did? He sang a song, Chineke na memo, memo, Chineke na memo, imela. They clap for an Igbo man to go and sit. After singing, they call a Yoruba man to sing a song, and he did Eledami Motiemu. Yaman, if you know the song, right? When he gets to the tone of the Malam, Malam picks the song that was meant to be for somebody. My divisima. Malam wallahi na elehin da lupa tirobu wen tirobu no de. The same Malam sing song, Malam carry the voice kai. Wallahi, the song I was about to sing by Yoruba man. Which song you want to sing that was sung by Yoruba man? He said that song that was Aladami at the end. They said, sing the song. Mala handle microphone. Kai Aladami at the end. Kai at the end. Kai Aladami at the end. Yawara kai mi awata jabo. Aladami at the end. Kai at the end. Hey, aladami at the emu, yawara, kai mi awada jabo. Do I remember me pass? How someone don't know how the song starts, now they finish when it twists the mouth. Imbadilo wuro kutu baraga aidori miru shek baraga rondori arotutu. The single, ladies and gentlemen, in no much of our time, we'll have much to treat here, and I know everyone is set for this particular occasion. We're going to be here to bring in one or two things to us. By the way, Merry Christmas to everyone. Everyone is looking Christmas. On the campus of University of Lagos, we have some certain things actually battling at this moment. But one thing, that's some certain things that is allowed in some places and it's not allowed in some places. When you ask You go to, normally you ask, who is the president of Ghana? Lagos will say, okay, we'll call the name, but you not be so before worry. You ask the worry man, who is the president of Ghana? Oh, am I from Ghana? Am I from Ghana? When you ask, then who is the president of Nigeria? Or when was the first Christmas celebrated in Nigeria? You say, well, believe me honestly, I was not born there. It is on this note, ladies and gentlemen, I want to bring before the microphone once again a round of applause for Dr. Akin Tayo to continue this speech. Thank you, sir.
Thank you very much, the only educated Malam. All right, so I've given the judges the briefs and the score sheets and the rest of them. Just some house cleaning before we start. You know how this goes. I mean, you did this, you've been doing this since we started. Each team has 30 minutes to present their cases. That 30 minutes, you can decide to allocate it and use it the way you want to use it, but you must tell the bench, the panel, the way you have allocated your time to use so that the registrar can properly time you. For the applicants, you have a right of rebuttal, but okay, yes, applicant, that 5 minutes or whatever minutes that you want to reserve, which must not be more than 5 minutes, is coming out of your 30 minutes. So your whole argument cannot be more than 30 minutes. Now, for the judges, we've given you the score sheets. If you look at the score sheets, you see that each team has a total score of 100. But each member of the team can only score a maximum of 50 points. And each member of the team has to be scored individually over 50. When you add the two scores together, it will come to 100 for the team. But for each member of the team, they can, I'll be with you in one moment. They can only get a maximum of 50 points. Another thing is they're allowed to present arguments beyond what is in their memorials. They're allowed to present argument beyond what is written in their memorial, because I know by now they have come of age, they have come of time, they have matured through the process during this competition. So they may have one or two arguments that they want to advance that they have not put in their memorials. That is allowed. One other thing is, you can engage the contestants. You can ask them questions to test their knowledge, to test their appreciation of the facts, to test their understanding. But don't turn it into a debate. Don't let it be a debate. Engage with them. At the end of the match, you'll be allowed to give them recommendations, suggestions for the future and the rest of them, just like you did in the last time. I think that is all about that. And you are not grading the memorials. Those have been done earlier during the preliminary rounds. You are only assessing their advocacy skills, their knowledge of the law, their knowledge of the facts and application and the rest of them. Yes, sir. All right, so I think the preliminary matters have been taken care of. The panel, the bench is ready. The contestants are ready. Are we ready? Our registrars, are you ready? Okay. Let's the match begins. Thank you. The chairman of the panel will regulate proceedings from now on.
Yes, okay, the registrars may proceed. Thank you.
The case before the court today, before the Community Court of Justice of the Economic Community of West African States, ECOWAS, with the file number ECW CCJ APP 2023-01, is a matter between the applicant, Mr. Jones Cole, and the Incorporated Trustees of Digital Justice for Africans, DJA, and the respondent, the Federal Government of Nigeria, the Nigerian Data Protection Commission, the Light Touch Incorporation, and the Light Gold Consultancy Africa. The applicants and respondents may stipulate the time they would like to spend it before the judges, so we can take due notice of that as they proceed. Thank you.
Okay, so let me take the appearances for the first party and for the second, for the applicant and respondent.
May it please this court, Mr. President, Your Excellencies, appearing for Team 22, I am Olaosi Inioluwa, and appearing with me is my learned colleague and co-agent, Oluduro Samuel. Our humble appearance is for the agent in this case, for the applicants in this case.
Respondent.
Respectfully, Your Excellencies, my name is Adedayo Michael. Appearing alongside me is my co-agent, Adekile Tiwalade, who represent the respondents in this case.
So the applicant will start.
Mr. President, Your Excellencies, before we proceed to canvass our argument on the merits of this case, and also to state our decided allocation of time on the canvassing of our argument, we would like to give a robust description of the case at hand before Your Excellencies. Your Excellencies, once again, the case before this honorable court is between Mr. Jones Cole, together with the Incorporated Trustees of Digital Justice for Africans, hereafter referred to as the first and second applicant respectively, against the federal governments of Nigeria, the Nigerian Data Protection Commission, Light Touch Incorporation, and Light Gold Consultancy Africa, hereafter referred to as the first, second, third, and fourth respondents respectively. Will Your Excellencies like to benefit from a summary of facts? Most obliged, Your Excellencies. Upon the inauguration of a new administration in the Federal Republic of Nigeria, the federal government of Nigeria embarked on massive collation of the people's data through the Office of the National Security Advisor. This act was particularly perpetrated through the deployment of an artificial intelligence tool known as Capture IT. Capture IT mined data of the citizens through various platforms, including social media platforms like Legit Socials. Legit Socials is owned by the third respondent in this case and managed through a subcontractor, the fourth respondent. The first applicant has approached Legit Socials for his data to be transferred to another platform. He has been denied of this application. He has also approached the second respondent, the Nigerian Data Protection Commission, in his complaint against the actions of the federal government in not only collating the data of the citizens, but transferring the same beyond the borders of the country. However, this application has been dismissed as lacking in merit by the NDPC. He has therefore approached this honorable court to seek redress. Flowing from the fact of this case, Your Excellencies, 6 pivotal issues, aside from the issues of jurisdiction, admissibility, and local standing, have been distilled for determination. These issues are expressly contained on page 8 of our brief of argument. Your Excellencies, and in compliance with Article 32, sub 1 of the ECOWAS Community Court Code of Procedure of 2002, our brief of arguments has been duly filed in the registry of this court. A copy of this same brief has been served on the opposing counsel, whereby seek the leave of this court to adopt our brief of argument. Thank you very much, Your Excellency. Now to our time allocation. For the next 15 minutes, I shall proceed to address this court on the merit of the preliminary issues for determination and substantive issue 1, 2, and 3. Thereafter, my learned colleague and co-agent, Oluduro Samuel, shall address this court on the merits of issue 4, 5, and 6 for subsequent 10 minutes. And we have together reserved 5 minutes for our rebuttals.
So that will be A, B, C, and D, E, F, as contained on page 8.
Very well, Your Excellencies. Your Excellencies, moving on to the preliminary issues for determination on issues relating to jurisdiction, admissibility, and local standing. The applicant submits that this court has jurisdiction to hear this case, that this case is admissible before the court, and that the applicant has requisite local standing to prosecute the case. Your Excellencies, the jurisdiction of the ECOWAS Community Court has been rightly defined in Article 9 sub 4 of the 2005 Supplementary Protocol. Article 9 sub 4 states that this court shall have jurisdiction in cases and matters relating to human rights violation in any member state, giving 2 requirements for the jurisdiction of this court. 1, that there is a member state, and 2, that there is a violation of human rights. It is our humble submission as the applicant that these 2 requirements have been fulfilled in this case. 1, according to paragraph 2 of the compromise, it is contained that the Federal Republic of Nigeria, the first respondent in this case, is a member of the Economic Community of West African States, fulfilling the first requirement. And to the second one, that there is indeed a violation of human rights. We make reference to both international and local statutes on the right to privacy, Article 12 of the Universal Declaration of Human Rights, Article 17, Your Excellencies, on the International Covenant on Civil and Political Rights, as well as local statutes, Section 37 of the Constitution of the Federal Republic of Nigeria, all providing for the right of privacy. This has been breached in this case, as contained in paragraph 9 through 13 of the compromise by the federal government and the other respondents, whereby submit that this requirement of violation of human rights, as contained in Article 9 sub 4 of the Supplementary Protocol of 2005, has been fulfilled, granting this court requisite jurisdiction. On the issue of admissibility, we refer the court humbly so to Article 10 sub D of the Supplementary Protocol, which provides for 2 additional requirements for admissibility of a case before this court. It states that 1, the case must be brought by a non-anonymous person, and that 2nd, it must not have been instituted before another international court. Your Excellencies, again, our submission is that these requirements have been fulfilled in this case. Number 4, the first requirement, we refer to paragraph 16 of the compromise, which states clearly that this case has been brought by the first applicant, Mr. Jones Co., and not by an anonymous person. And for the second one, although we understand that this case was instituted concurrently before the Federal High Court, however, the Federal High Court of Nigeria is not a court of international jurisdiction. And so the court has even held, this particular court, Your Excellency, in numerous cases, that the assertion of local remedies is not a prerequisite for bringing a case before the ECOWAS Court of Justice. It has been held so in a plethora of cases, including the case of Musa Sidkan versus Federal Republic of Niger. Citation duly contained on page 12, footnote 6 of our brief of argument. Your Excellencies, we do submit that requirements of admissibility have been fulfilled in this case. Moving on to local standing of the applicant, we submit also that the applicant has requisite local standing. On this ground, we make reference before this honorable court to the case of Reverend Solomon MFA and 11 others, and Federal Republic of Nigeria and 5 others. Citation duly contained on page 12, paragraph 9. On page 12, footnote 9 of our brief of argument. In that case, Your Excellencies, this honorable court decided that there are 3 grounds for the determination of local standing. that first, there must be a violation of human rights. Second, the applicant must be a victim of such violation. And third, the respondents must be responsible for the violation. It is our humble submission that these three requirements has been fully satisfied in this case. As we have said, there is a violation of human rights in this case, Your Excellencies, owing to international as well as local statutes, Article 12 of the UDHR and other states, Your Excellencies. And on the second requirement, that the applicant has suffered from the violation, we make reference to paragraph 13 of the compromise, where upon the mining of his article, the applicant in this case, the first applicant, was arrested and detained, putting an end to his freedom of expression. Your Excellencies, this is a personal loss that he has suffered, and we so submit before this honorable court. To the third aspect, that the respondent is responsible, we make reference again to paragraph 9 through 13 of the compromise, which provides for not just the actions of the first respondent, but also of the other respondents in this case, in facilitating the actions of the government in arbitrarily mining the data of the people of Nigeria. Your Excellencies, we do submit that these three principles or requirements that has been given by this court have been satisfied for local standing. And if this court rules otherwise, we bring forth for the second applicant in this case, the Incorporated Trustees of Digital Justice for Africa, the popular principle of law known as Actius Popularis. Actius Popularis grants a person that is not directly a victim of a violation to bring a suit pursuant to representative interest. And we so submit before this honorable court, as it has been held in the case of Serap versus FRN, that the principle of Actius Popularis can avail an applicant. Your Excellencies, owing to all these principles of laws, earlier cited and canvassed before Your Excellencies, we do submit holistically on the preliminary issues that this court has requisite jurisdiction, that the case is admissible, and that the applicant has local standing to prosecute the matter. Moving on to the substantive issues for determination in this case. On issue 1, on whether or not the federal government of Nigeria, through the Office of the National Security Advisor, had proper legal basis for the collation of the people's data, the applicant submits in the negative. It is our vehement contention that the federal government of Nigeria lacks every ounce of legal basis for collation of such data. Your Excellencies, we wish to put forward that the principle of legality in terms of collation of data is well enshrined in Article 24 of the Supplementary Act on Personal Data Protection of 2010. It has well been expressed and entrenched in Article 24 sub 1A of the Nigerian Data Protection Act, which provides that there will be fairness and transparency in the processing of data. Your Excellencies, we envisage that the respondent in this case might want to bring before this honorable court the provision of Article 25 sub 1B4 of the NDPA, providing that the government may mine data of citizens for public interest. However, we wish to state that Section 25 contains in its emphasis, it says, without prejudice to the principles stated in this act. Your Excellencies, these principles are contained in Section 24. And one of these principles, Your Excellencies, is in Section 24 sub 1A, that the collation or processing of data must be done fairly. The principle of fairness has been failed to be complied with in this case by the first respondent, as can be seen in paragraph 5, 10, as well as 12 of the compromise, stating that Capture IT mined the data of citizens arbitrarily from any source. It even states in paragraph 10 that it was secretly accessing cables, carrying data between the third and fourth respondents. And in paragraph 12, that it was intercepting private chats. Your Excellencies, private chats of the citizens. Nothing can be said to be less than fair than this, Your Excellencies. We submit that the principle of fairness have been derogated upon. And second principle, as to Section 21 sub 1B, 24 sub 1B, which provides that there shall be fairness, there shall be transparency, Your Excellencies, in the processing of data. We also submit that this has not been complied with in this case. Your Excellencies, we make reference to paragraph 4 of the compromise, which provides that the data collected by the federal government was collected to such an extent that it was collected for no specified and defined purpose. This is in violation of Section 24 sub 1B of the NDPA, which provides that data must be collected for specified, explicit, and defined purpose. Your Excellency, the federal government has also violated this provision of the NDPA. And given all these requirements that must be followed before legal basis can be attained, the federal government cannot be said in this case to have legal basis to process such data. We bring before this honorable court the Lactin maxim, popular Lactin maxim, ex nihilo nihil fit. Nothing comes from nothing. You cannot be a data processor that is legitimate when your collection of data is faulty. Your Excellencies, we don't submit on the first issue that the federal government has no legal basis. On the second issue, on whether or not the federal government, through the office of the NSA, violated the provisions of the Nigerian Data Protection Act by failing to comply with due process in the deployment of capture IT, Your Excellencies, and whether or not they violated the copyright of Mr. Jones Coe, as well as several others in his development and training. We submit before Your Excellencies that the federal government indeed violated sections of the NDPA in the deployment of capture IT relating to lack of fairness, accountability, opacity or transparency, as well as algorithmic bias. On the principle of fairness, as we have earlier cited before Your Excellencies, Article 24 of the Supplementary Act of 2010, as well as Section 24 sub 1A of the NDPA provides for fairness. This has not been seen to be done in this case, pursuant to paragraph 5, 10, and 12 of the compromise. On the principle of transparency, accountability, and algorithmic bias, we shall collate these three principles together, Your Excellencies. For pursuant of justice, for transparency, we make reference to Article 27 of the Supplementary Act of 2010, as well as Section 24 sub 1A of the NDPA. On the principle of accountability, we make reference to Section 24(3) of the NDPA. On the principle of algorithmic bias, we make reference to paragraph 12 of the compromise. Paragraph 12 states that the data of people were mined in such a way that the Kembari people of northeastern Nigeria were derogated against. Your Excellencies, although it is contained in paragraph 9 that the Office of the National Security Advisor make public briefings, however, their public briefings did not state that the Kembari people were being sidelined, marginalized by the collation of data of capture IT. Your Excellencies, this does not amount to any form of transparency on the part of the government. We hereby submit that failing to comply with transparency, fairness, opacity, accountability, the government has failed to comply with due process in the deployment of capture IT. And moving on to the second part of that issue, on the issue of whether the copyrights of Mr. Jones Coe, as well as others, were violated, we also submit in the affirmative. It's our vehement contention that their copyrights were indeed violated. Your Excellencies, copyright has been well provided for in Section 2 of the Copyright Act of 2022, which provides that copyright shall be inhabit in literary and artistic work. It also defines the rights of the copyright owners in Section 9, Section 10, Section 11, and Section 12, and Section 13 of the same Act. Although we realize that there are general exceptions provided in Section 20, like Section 20 sub 1, providing for the exception of fair dealing. However, the actions of the government cannot be input into this certain exception, as it is contained in that act, that when dealing with fair dealing, the amount of work that is used in relation to the total amount of work that is copied shall be put into consideration. Your Excellencies, going by the provisions of paragraph 5, paragraph 10, and paragraph 12 of the compromise, the amount of data collected by capture IT was without any cap. It was collated in such a way that people's personal data were infringed without any consideration and without any restraint whatsoever. We don't submit that the defense of fair dealing cannot avail the respondent, and therefore the copyrights of Mr. Jones Coe, as well as several others, were violated. Moving on to the third issue, Your Excellencies, on whether or not the federal government of Nigeria has failed to comply with the NDPA in supplying the required information to the government of the Gambia. We also submit in the negative. It is the vehement contention of the applicant that the federal government has failed woefully in the supply of information to the government of the Gambia. Your Excellencies, transborder transfer is well provided for in Article 19 of the 2010 Supplementary Protocol. It has also been Supplementary Act, Your Excellencies. It has also been provided in Section 41 of the NDPA. Section 41 sub 1A provides that in transborder transfer, The recipient of the data shall be a country subject to a law. I repeat for emphasis, Your Excellencies, subject to a law. We humbly submit that the Republic of Gambia in this instance case is not a country subject to a law. Your Excellencies, the Gambia does not currently have a data protection legislation. And although we realize that they are a signatory to the 2010 Supplementary Act, however, they have not implemented the actions under that act. In fact, Your Excellencies, the act has not been transposed and domesticated by the Republic of the Gambia. The act states that each member state shall establish an authority for data privacy protection. Your Excellencies, the Gambia has not established any authority. We also note that in 2019, the Gambia instituted the draft data protection and privacy policy strategy of 2019. However, up to date, this draft does not have the force of law. We just submit that the Gambia in these instances cannot be counted among the countries that is subject to a law. And so doing, the actions of the federal government in transferring data to them is very, 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 very against the provision of the NDPA. Conclusively, Your Excellencies, we submit again the provisions of the non-popular Latin maxims. Nemo dat quod non habet. You cannot give what you don't have. Ex nihilo nihil fit. Nothing comes from nothing. If the activities of the federal government in dealing with this data is faulty, how can their transfer of the data to the Republic of the Gambia be seen to be legitimate? How can a man that cannot stand be seen to be working? We don't submit holistically on the third issue that the transfer of data to the Republic of the Gambia is faulty and against the provisions of the NDPA. If I shall be of no further questioning, no clarification before this honorable court, I shall now defer proceedings to my learned colleague and co-agent, Oluduro Samuel, to address this court on issue 4, 5, and 6. It has been an honor arguing before this.
We have a couple of questions.
So with respect to the alleged violation of your copyrights, can you be more explicit in terms of the specific rights or the specific bundle of rights that was violated? Can you provide more context to that, the copyright that was violated?
Thank you very much, Your Excellencies. In respect to the copyright that was violated, we shall refer, Your Excellencies, to the provisions of paragraph 13 of the compromise. For example, one of the copyright that was violated is the article written by Mr. Jones Co. Your Excellencies, copyright is said to be resident in literary and artistic work. Definitely an article published on the pages of a newspaper is an artistic work or a literary work rather, written by the first applicant. Your Excellencies, copyright in mind this article without restraint, and on such even gave notice to security enforcement agencies, and he was arrested and detained on that very purpose. Your Excellencies, this is a very pivotal example of copyright infringement.
My second question is with respect to the fact that you said that Gambia presently is not subject to a law. What is your understanding of the word law in that context? So are there subsidiary laws, are there primary laws presently in Gambia that has direct or indirect impact on data protection? And if there is, how do you try to disapply those laws in the context of the case that you brought forward before this court?
Thank you very much, Your Excellencies. First, I must state that our argument against the Republic, against the transfer of the data to the Republic of the Gambia is standing on 2 feet. However, to your question, Your Excellency, that the Republic of Gambia is not subject to a law, as we have earlier cited, the Republic of Gambia does not have a robust data protection law in place at the moment, although we know that it has some laws that are related to data protection, like the ICTA, the ICT, dealing with information and communication technologies. However, like a country like Nigeria that has the NDPR, the regulations, the NDPA of 2023, the Gambia has not come to bear with that level of security for data protection. And that is why we humbly submitted that this court will rule that it is not a country that is subject to a law. No specific law as is robust, in a robust manner, protecting data protection in the Gambia as we speak presently.
Is it about being subject to a law or is it about robustness?
Your Excellencies, we take the interpretation of statute as it is, a literal interpretation, Your Excellencies, subject to a law. The policies we have mentioned, like the draft data policies of the Gambia of 2019, currently does not have the force of law. And the word law we take strictly for this court to abide with.
Okay, thank you. So, can you please further clarify on the issue of you coming to this court while you have this in process with local laws and institutions in the Federal Republic of Nigeria? So have you considered exploring local options?
Thank you very much for that question, Your Excellencies. It's a very, very good question. Your Excellency, as we have earlier cited before this honorable court, it is in our knowledge that this case was concurrently instituted before the Federal High Court of Nigeria. However, this does not in any way affect either the jurisdiction or the decision of this court. In fact, this court has held in the case of Moral versus Niger, Republic of Niger, the decision of this court holds whether or not this case is before any other local courts. However, Your Excellencies, we envisage that the respondent might want to quote the provision of Article 39 of the 2001 protocol, Your Excellency, that says that the local remedies shall be adhered to. However, the provision of that law is that the Act of 1991 shall be amended. Up till now, Your Excellencies, the law has not been amended. The supplementary protocol of 2001 of 2005 does not provide for the enforcement of local remedies. And this court has held in a plethora of cases, including the 2017 case of La Society versus the Republic of Nigeria. Your Excellencies, the court held in that case in 2017 that this court shall hold and determine cases irrespective of whether or not those cases were instituted before local court.
Thank you.
Yes, regarding your issue number one, that's A. Do you not consider national security as one of the exceptions to collecting personal data?
Thank you very much for that question, Your Excellencies. National security and public interest have well been considered and they are provided for in Section 25 sub 1B4 of the NDPA. It provides that in processing of data shall be lawful when it is done in pursuant of a task or in performance of a task by an official authority in reference to public interest. However, we earlier stated before, Your Excellencies, that that section says in its beginning, without prejudice to the principle of data protection under this act. The principles of data protection are contained in Section 24, and Section 24 sub 1B states, for example, that data shall be collected for specified, explicit, and defined purposes. However, going by the provisions of paragraph 4 of the compromise, the data collected by the Federal Republic of Nigeria were indeed, in fact, clearly stated that they were for no specific or defined purpose. And it's on this fact that we submit that having not fulfilled the principles under 24, the government cannot be seen to be hiding under the exception under Section 25.
Thank you. We are satisfied so far. Any other question? Yes, thank you. You may sit down.
Thank you very much, Your Excellency. It has been an honor arguing before this honorable court.
Sorry, can I ask a question? Can I ask a quick question? Can you hear me? Yes, I just have one clarification I'm trying to get. So you spoke about having a legal basis to process the personal data. Well, the issues I sort of had were conversations around principles, data processing principles. So can you clarify for me the distinction between legal basis for processing personal data and the principles that you need to abide with to process personal data? Do you see that there is a distinction between those two? And how does that apply in this particular case?
Thank you very much for that question. It is our humble submission that there is provided for legal basis for the processing of data as has been provided for in Section 25 of the NDPA. However, we submit before this honorable court that these bases are subject to the compliance with the principles earlier provided in Section 24. And we state that these principles by the federal government in this case have not been complied with. And it's on this basis that we humbly submit that having not complied with the principles on Section 24, the government cannot be seen to be hiding under an open tent in Section 25.
Okay, thank you.
What do you mean when you said that the basis is subject to compliance with the principle? Can you clarify that?
Your Excellencies, our line of thought is taken from the very provisions of the Act where it says, without prejudice to the principles of this Act. And without prejudice, making mention of the principles of the Act, is Section 24 contains the principles of the Act being referred to in Section 25.
Or is it the case that that section 25 also contains, the exception that you mentioned also contains the legal basis? Or is your case that social security purposes is only limited to the principles and it doesn't cover the legal basis? Or is it a combination of both?
It covers the legal basis, Your Excellencies.
Any other question?
Thank you very much, Your Excellencies. I shall now defer proceedings to my learned colleague and co-agent, Oluduro Samuel, to address this court on issue 4, 5, and 6.
Thank you.
Mr. President, Your Excellencies, standing on all existing protocols, I remain Oluduro Samuel, and I shall be canvassing my argument on the merit of the 4th, 5th, and 6th issues for determination for the next 10 minutes. Moving on to the 4th issue, as to whether Light Touch Incorporation is a data controller and whether it has failed in its obligations. To this pivotal issue, we respond in the affirmative. And for ease of understanding, our argument has been stratified into 2 major standpoints. Firstly, that Light Touch Incorporation is indeed a data controller, and secondly, that Light Touch Incorporation has failed in discharging its responsibilities under the relevant laws. With respect to the first standpoint, reference will be made to Section 65 of the Nigerian Data Protection Act, which expressly defines a data controller as an individual or private entity who jointly or along with others determines the means and purposes of processing personal data. Your Excellency, this definition has also been accorded recognition in Article 1 of the Supplementary Act on Personal Data Protection within ECOWAS 2010. Moving on, paragraph 6 of the Statement of Agreed Facts reviews facts that the respondent is the owner of a social media platform, Legit Socials, having an estimated amount of 100 million subscribers in Nigeria, Your Excellencies, 100 million users. Your Excellencies, it is our humble contention that the respondent in this instance cannot in good faith deny being a data controller, as paragraph 10 of the Statement of Agreed Fact makes us to realize that there is the existence of cables carrying data between the 4th respondents, Light Good Consultancy Africa, and the 3rd respondents, Light Touch Incorporation. Not only that, paragraph 14 of the Statement of Agreed Fact further reveals that Light Touch Incorporation was actually involved in the processing of data when they contended they could not delete the data of Mr. Cole from their servers. Your Excellencies, it is a line of thought that the mere fact that Light Touch Incorporation, even as a server, for storing the data of Nigerian citizens, bring them under the ambit of the definition of a data controller as contained under Section 65 of the NDPA. On this standpoint, we humbly submit, Your Excellencies, that Light Touch Incorporation is indeed a data controller. Moving on to the second standpoint, as to whether it has failed in its obligations, we respond in the affirmative. Firstly, Your Excellencies, Section 29(1)(a) of the NDPA provides that where a data controller engages the services of a data processor, the data controller engaging another shall ensure that the engaged data processor complies with the principles set out in this act. Not only that, being read in conjunction with Section 29 sub 1C, it also mandates the data controller engaging another data processor to make sure the data processor implements appropriate technical and organizational measures to ensure the security and integrity and confidentiality of personal data. Your Excellency, it was nowhere stated in this statement of fact that the 3rd respondent actually took steps to verify the security of data being processed by Light Good Consultancy Africa. Not only that, Your Excellency, we refer this honorable court to the provisions of Section 24F of the NDPA, which ensures that data is processed in a manner that ensures the appropriate security of it. Your Excellencies, even taking into consideration paragraph 8 of the Statement of Agreed Fact, it is still a vehement contention that Light Touch Incorporation has not taken the necessary steps to ensure the security of data being processed by the 4th respondent. Not only that, Your Excellency, no notice was made by the 3rd respondent to the NDPC, the Nigerian Data Protection Commission, concerning the breach he discovered on his platform as mandated expressly by Section 40 sub 2 of the NDPA. We thus respectfully submit, Your Excellencies, that not only is Light Touch Incorporation a data controller, but it has also failed in discharging its obligations under the law. Moving on to the 5th issue for determination, as to whether Light Touch Incorporation was in error when it contended that Mr. Cole could not move his personal data. With respect to this issue, Your Excellencies, it is a vehement contention, and that's in the affirmative, that Light Touch Incorporation was indeed in error to deny the applicant this request. Your Excellencies, the third respondent gave 3 reasons. The third respondent gave 3 reasons for denying the request of the applicant, of which the first was that the request was strange under the law. At this juncture, Your Excellencies, we would like to refer this court to the provisions of Section 38 sub 2 of the Nigerian Data Protection Act, which provide expressly for the right of data portability and entitles data controllers to transmit personal data obtained to another controller, and that without hindrance. Not only that, Section 38 sub 2C of the same statute also provides that where technically possible, have personal data transferred directly from one data controller to another. Your Excellencies, this has also been contained in Part 3.1 sub 15 of the Nigerian Data Protection Regulation. On this note, Your Excellencies, it can be seen that Mr. Cole's request was not at all strange under the law. Moving on to the second standpoint, Your Excellency, the third respondent contended that in processing the request, a fee would be involved, of which we contend that paying a fee would not only be outrageous, but be an outright violation of Section 38 sub 2P of the NDPA, which provides that data controller, that data can be transmitted from one data controller to another, and that's without hindrance, Your Excellencies, that's without hindrance. However, Your Excellencies, as law-abiding citizens, we are aware of the provisions of Section 34 sub 1, and we applicants are we applicants are ready to bear any transaction, any reasonable transaction cost involved in compliance with the provisions of this act. Not only that, moving to the third statement made by Light Touch Incorporation, that the data of the applicants can be retained on their servers for as long as they want. We refer this honorable court to the provisions of Section 34 sub 1D of the Nigerian Data Protection Act, which provides that data subjects shall have the rights to have their data completely erased if the lawful purpose of its collection has been fulfilled. On this note, Your Excellencies, we humbly submit that Light Touch Incorporation was in error to deny Mr. Cole's request and several others to move their data from Legit Socials to another platform. Moving on to the 6th issue for determination as to whether the Nigerian Data Protection Commission is not independent as required under the relevant law. To these pivotal issues, Your Excellencies, we respond in the affirmative, as it is our contention that the NDPC is not at all independent as opposed to what is contained under Section 7 of the Nigerian Data Protection Act. This stance, Your Excellencies, is however deeply rooted in the Nigerian Data Protection Act, the very act that establishes the commission. As Section 9 of the NDPA provides that the president shall have the power to appoint members of the commission, including the chairman, on the recommendation of the ministers. Not only that, Section 11 sub 2 of the NDPA further provides that the president shall have the power to remove any member of the commission, including the chairman, where he is satisfied it is not in the interest of the commission or the public that that member continues in that office. Your Excellency, this reason for removal is too vague and empowers the president to remove any member of the commission as he deems fit. This is unlike Section 143 of the Sacrosanct 1999 Constitution, which expressly provides the ground in which the President of the Federal Republic of Nigeria can be removed on the ground of gross misconduct, amongst others. Furthermore, Your Excellencies, as can be inferred from paragraph 15 of the Statement of Facts, the NDPC made a very short and brief findings on the complaint of the applicants after consultation with the NSA, Your Excellencies, after consultation with the very agency in concern being accused of this breach. This indirectly highlights the level of control and reference that the NDPC has over the government. We thus holistically submit on this issue that the NDPC is not at all independent as opposed to what is contained under Section 7 of the NDPA. If I be of no further questions, we hereby seek the leave of the court to adopt our prayers as contained in page 34 of our brief of arguments. On a final note, Your Excellencies, it can be seen that the respondents have committed several infringements, not only on the rights of Mr. Cole, but also on the right of the entire citizenry of the Federal Republic of Nigeria. Your Excellencies, sensitive personal data was mined. The right of privacy of citizens was infringed upon. Your Excellencies, an entire tribe was discriminated against and tagged as potential terrorists. Your Excellencies, Mr. Cole was unjustly arrested and tagged a terrorist because of his descent. Not only that, he was charged to court with an offense that attracts the capital punishment, Your Excellencies, the capital punishment. We finally submit, Mr. President, on the Latin maxim, fiat justitia ruas colon. Justice, Your Excellencies, true justice, even if the heavens fall. Once again, Your Excellencies, Mr. President, I remain Oluduro Samuel, and it has been an honor arguing before this honorable court.
Thank you. Let's take the panelists virtually first, so that the panelists on virtual. Okay, any question?
Okay, so with respect to your right to erasure, so I want to understand, was it the case that you specifically sought to exercise that right, or was it implicit in your right to data portability?
Madam, Your Excellency, I didn't get that question well.
Okay, so you had contended that part of the justification from Light Touch on the reason why the data could not be transferred to another data controller was because they wanted to retain that data. And you had also made the case that they don't have the rights to retain that data because there is a cessation of the lawful basis for the collection. And my question is, was there a specific exercise of your right to erasure? Or was it implicit in your request that the data should be transferred to another controller?
Thank you very much for that question, Your Excellency, as it even helps our case. Your Excellencies, it is our humble contention that the right of erasure and the right of data portability, as requested by the applicants, are in no way connected. Your Excellencies, the applicant tried to exercise their right of portability, of which the respondents claimed that they could retain the data. Your Excellency, they are in no way in tandem. And we are aware of several provisions of the law, including Section 38 of the Cybercrimes Act, which mandates service providers to retain the personal data of their customers for a period of 2 years, Your Excellencies. If you can check from paragraph 14 of the statement of agreed fact, the third respondent contended that they could hold the data for as long as they want, Your Excellencies. This is in express contravention of Section 38 of the Cybercrimes Act, which only mandates them to hold this for 2 years. Thank you very much for that question, Your Excellencies. As can be inferred from paragraph 16 of our statement of agreed fact, it says the NDPC made a very short and brief finding that this is a national security matter, and therefore it is beyond our mandate. Based on this finding and the advice after consultation with the office of the NSC, Your Excellencies, we would like to refer this court to the Oxford Advanced Learners Dictionary meaning of the word consult. It says to seek information or advice from someone. Your Excellency, the NDPC is not supposed to be seeking advice or information from the very agency being accused of this breach.
Then closely connected to that, the question of appointment. Are you of the view that it is not independent because they can be removed or appointed by the president? I see that you compared it with the removal of the president in the 1999 Constitution.
Yes, Mr. President.
Can you elaborate on that? Because president was not appointed but was elected.
Yes,
so how can you justify that comparison?
Mr. President, our stance here is flows on a logical point of view. We believe 1 + 1 is 2. First of all, the president appoints members of the commission, including the chairman, and the president now has the power to remove any member on ambiguous reasons, Your Excellency. It just states the president can remove any member of the commission where he is not satisfied that it is in the interest of the commission or the public. And we are comparing it to the detailed provision of Section 143 of the 1999 Constitution, which expressly provides that the President of the Federal Republic of Nigeria can be removed on gross misconduct, Your Excellency. Gross misconduct as expressly stated here.
So that's your submission of your issue number 6.
Not only that,
yes,
Mr. President, we also contend that the actions of the NDPC has also proven to question their independence as a government agency.
A combination of the two.
In combination of the two, we are of the contention that the NDPC is trying not to step on the toes of the federal government.
Thank you.
Thank you. So, I will be asking on issue 4. So you have stated that Light Thought Corporation has failed in discharge of their duties in terms of protecting the data, protecting the data on their platform from being mined. So do you have further facts and submissions to back this up? Because based on the write-ups that we have, it is shown that the federal government actually intersected their system. So technically, I might have actually put a door in a room and somebody could still get an entrance into that door. So do you have statement of facts and submissions to prove this further?
Your Excellency, thank you very much for that question, Your Excellency. Our line of thought is that the Light Thought Incorporation, the third respondent, has not complied with the provisions of the NDPA, as it was not stated that they did anything to verify the security of Light Gold Consultancy Africa in processing the data of Nigerian citizens, Your Excellency, as opposed to paragraph 8 of the statement of agreed facts, where they stated that we employ state-of-the-art encryption technologies to safeguard the information in our possession, Your Excellency. They are talking about themselves. However, the law places an obligation on them to make sure when they are employing or when they are engaging the services of a data processor, that they actually go a step further, as can be seen in section 29 sub 1C of the NDPA, which says where a data controller engages the services of a data processor, the data controller shall make sure the data processor implements appropriate technical and organizational measures to ensure the security, integrity, and confidentiality of personal data, Your Excellency. It was nowhere stated in the statement of facts that the third respondent actually took these steps.
To the virtual panelist. Any question from
No, not from me, not from me. Thank you.
All right.
Thank you. We are satisfied. Yes.
I will reserve some of my comments. I actually didn't want to prejudice the proceedings. I'm enjoying it, but a quick one, because I don't have the facts. Copyright. I really want to get a clarification on this copyright issue. There is a human right. The basis of jurisdiction is that there is a human right. That is one of the bases. And now copyright as one of the claims for this under human rights as a basis for jurisdiction. I'm struggling with that, actually.
Thank you very much for that question. I shall defer proceedings to my co-agent to elaborate more on that topic.
Yes, you may proceed. Yes.
Apologies, sir. I would like you to retake that question.
All right. In defining the jurisdiction of the court, how to invoke the jurisdiction of the court, human rights, there must be a violation of human rights. And then your claim, part of your claim is a violation of copyrights.
Thank you very much for that question, sir. We understand your concerns. The copyright aspect of our claims is provided for in the second substantive issue, where it states explicitly that whether or not the copyrights of Mr. Jones Cole, as well as several others, were violated. However, we have earlier adumbrated our argument based on the jurisdiction of the court pursuant to Article 9(4) of the 2005 Supplementary Protocol, where we mentioned that there must be a violation of human rights. And in that respect, we have quoted both international and local statutes, Article 12 of the UDHR, Article 17 of the ICCPR, articles, as well as the Section 17, of course, of the Constitution of the Federal Republic of Nigeria, all providing for the right of privacy. Sir, we have stated this fact concerning the jurisdiction of this court to be established in accordance with Article 9(4). However, the substantive issue 2, goes ahead to ask a very dear question as to whether or not the copyrights of the citizens were violated. And it's because of that issue that we had to employ the sacrosanct provisions of the Copyright Act of 2022 to make our submission before this honorable court.
All right, thank you. I believe the judges will take notice of that particular issue.
Thank you. Okay, that brings an end to the first session. Any other comment, any other question? Any other question from the panelists? Judges, no questions. Okay, thank you. You may sit down. We are satisfied with your submissions. We now move to the respondent. Oh, you want to stand? Yes, you may start.
Apologies. Mr. President, Your Excellencies, may it please this honorable court. My name is Adedayo Michael, agent for the respondent, the federal government of Nigeria, the National Data Protection Commission, Light Touch Incorporation, and Light Good Consultancy Africa. Appearing alongside me is my co-agent, Adekile Tiwalade. Both agents of the respondent shall be responding to the vexatious allegations, baseless arguments of the applicant within 30 minutes. Your Excellencies, the case before this honorable court concerns the necessary actions of the respondent under the circumstances. The federal government of Nigeria, like most ECOWAS community states, are bedeviled by insecurity, terrorism, and other acts of violence. As such, the respondent took all necessary measures under the circumstances by deploying an artificial intelligence which identifies these terrorists online. Because of the anonymity that social media and other online network offers. Based on this, Your Excellencies, we argue that the respondent has only fulfilled its national and international obligation to protect national security and to prevent crimes, and also protect the right to life and right to health and other fundamental rights of its citizens. Based on this, Your Excellencies, with respect to the procedural issues, we maintain 3 procedural objections. I shall be arguing on those procedural objections, Your Excellency, as well as the first and second claim in merit. My co-agents will then speak for another 15 minutes, arguing on the 3rd, 4th, 5th, and 6th claims. Your Excellencies, I shall be arguing for 15 minutes. Your Excellencies, respectfully, we adopt our memorial filed on the 15th of October, 2023, and rely on every argument contained therein. Your Excellencies, the claims and arguments, as well as the issues before this honorable court, are contained on paragraph 20, page 6 of the compromise, for the convenience of this honorable court. Your Excellencies, if there are no preliminary questions, agents will now proceed to adumbrate on the issue.
Let me proceed.
Most obliged, Your Excellencies. On the issue of jurisdiction, we submit that this honorable court does not have personal jurisdiction. Your Excellencies, the jurisdiction of this honorable court is a lifeblood. Without jurisdiction, this honorable court cannot hear any matter. However, what the applicant failed, Your Excellency, to note before this court is that jurisdiction is multidimensional. This honorable court has to be satisfied as regards its material, personal, territorial, temporal, and subject matter jurisdiction. The applicant have only adumbrated on the subject matter jurisdiction. Your Excellencies, however, this honorable court lacks personal jurisdiction to hear the claims brought against the 2nd, 3rd, and 4th respondents in this case. Your Excellencies, the 2nd, 3rd, and 4th respondents are not member states. This honorable court is an international court that hears human rights violation cases against member states, as stated by this honorable court in the case of Mario Momo versus Guinea. Your Excellencies, we also note that the 3rd and 4th respondents are private entities. Companies, Your Excellency, are seen in paragraph 6 of the compromise with Light Touch Incorporation, and paragraph 7 of the compromise, Light Good Consultancy. All these are private companies. And as stated by this honorable court, in the case of Serap versus Federal Republic of Nigeria, decided in 2010, Your Excellencies, NNPC, Chevron, Shell, private companies were not allowed to be members of the particular case because they are private entities. And this honorable court cannot hear human rights violation cases against private entities, only member states. Therefore, Your Excellencies, we submit that this honorable court lacks personal jurisdiction over the second, third, and fourth respondents. Your Excellencies, on the issue of admissibility, the applicants have argued, relying on Article 10D of the ECOWAS Protocol. They have contended, relying on the case of CDCAN versus the Gambia, that exhaustion of domestic remedy is not a compulsory requirement because it is not stated in Article 10D. However, Your Excellency, the applicants have merely demonstrated lack of understanding of customary international law. As stated, Your Excellencies, by the ICJ, in the case of Wild versus Belgium, the court stated that exhaustion of domestic remedy is a customary international law principle. Principles that apply by default. Your Excellencies, in the case of USA versus Belgium, the court stated, the ICJ, that an exhaustion, the customary international law, can only be waived when there is an express provision that says so. Article 10D of the ECOWAS Protocol, Your Excellency, does not say exhaustion of domestic remedy does not apply. As such, because of its status as a customary international law principle, we submit that it should apply before this honorable court. We recognize that this court has recognized in a plethora of cases that exhaustion of domestic remedy is not compulsory. However, this court is not bound by its previous cases, and we urge this honorable court to reverse its decisions. This concludes our submission, Your Excellency. However, we would also like to note that the applicants have failed to exhaust domestic remedy, and as a consequence, this case should be dismissed for want of admissibility, as seen in paragraph 16 of the compromise, where they have failed to allow the Federal High Court of Nigeria to decide on the merits of the case. Your Excellencies, on the issue of local standing, the applicant relied on the case of Reverend Solomon versus FRN, where this court stated 3 conditions for local standing to be satisfied. Your Excellency, the second condition is missing in this case, which is the requirement of direct injury. Your Excellencies, the requirement of direct injury is a fundamental requirement before international courts, such as this honorable court, as has been recognized by this court in the case of Honorable Justice Alade Toyinbo versus the Federal Republic of Nigeria. In that case, this honorable court states that for direct injury to be found, there must have been causation, which means an immediate impact of the injury on the applicant. In that case, Your Excellency, the Honorable Justice had been dismissed on the basis of an national NJC's warning, which had been posted on television stations and other media platforms. The applicant in that case argued that he had suffered mental distress and other non-pecuniary injuries. Your Excellencies, you found that there was indeed no direct injury in that case because the applicant had failed to show by way of facts that there was indeed any injury. Your Excellencies, a quick perusal of the facts would disclose to this honorable court the undisputed fact that there is nowhere Mr. John Scott suffered any injury whatsoever, material and non-material. Therefore, we submit that since there is no direct injury, Mr. John Scott has no local standing before this honorable court. With respect to the Digital Justice for Africa, his NGO, we recognize that this honorable court has allowed cases brought by NGOs in the collective interest of others. However, in the case of Sarah versus Nigeria, decided in 2009, particularly paragraph 17, this honorable court refused Serap's appearing on behalf of victims of human rights violation because this court noted that they could have come before this honorable court by themselves and that Serap had failed to obtain authorization and had no consanguinity or affinity with any of them. The most important point in that case, Your Excellency, is that some of the victims of the human rights violation are identifiable. In the present case, according to paragraph 12 of the compromise, some of the alleged direct victims of the human rights violation are identifiable, and Digital Justice for Africa should have approached them, Your Excellency, before bringing the action on their behalf by obtaining authorization. Your Excellencies, therefore, we submit that the first and second applicants have no local standing before the honorable court. Your Excellencies, based on these submissions, we urge this honorable court to dismiss this case for want of jurisdiction, for want of admissibility, and for lack of local standing. However, assuming that this court finds that all these elements are present, agents seek the permission of this honorable court to proceed to adumbrate the claims in merit.
You may proceed, please.
Most obliged, Your Excellency. Your Excellency, it is unfortunate that the applicants have failed to understand the issue in the first claim. It is whether there is a proper legal basis for the collection and aggregation of personal data by the respondent. The legislatures are not stupid, Your Excellencies. There was a reason why they required a legal basis in that particular provision, particularly section 24 of the NDPA. However, before proceeding, we would like to bring to the attention of this honorable court that it is an international court, and it has stated in a plethora of cases, including the case of Sarah versus Nigeria, decided in 2010, particularly paragraph 38, that it does not apply national laws. Your Excellencies, in the case of Bojana versus Togo, the honorable court stated that constitutions of Togo and other national laws are not applicable. Your Excellencies, based on this, we argue that this claim cannot be determined. However, in any case, we submit that there is indeed proper legal basis in this case. The applicants have failed to distinguish between proper legal basis and the processing of and the principles of processing of personal data. The proper legal basis requires that there is indeed a legitimate basis for the collection of and processing of any personal data. That is the issue here, Your Excellency, not the principles. The issues with respect to the principles are contained in the second claim, Your Excellencies. As such, we submit that there is indeed a proper legal basis in the present case. Although consent was not, Your Excellencies, received from the applicants, we argue, relying on section 25, Your Excellency, section 25, sub B, sub 4, which allows the federal government of Nigeria to collect personal data and process them for the purpose of public interest. The phrase reads, when the processing is necessary for a task carried out in the public interest. Your Excellency, although there are no direct authorities in the African jurisprudence on the meaning of this phrase, we note that the NDPA is materially similar to the GDPR and the EU Data Protection Directive. We rely therefore on the interpretation of the ECJ of that particular phrase, Your Excellency, contained in Article 7E of the EU Directive on Data Protection, where the court stated that that provision is justified when, for example, a government agency collects personal data for the purpose of combating tax fraud and tax crimes, Your Excellency. That was in the case of Pushka versus the Slovak Republic, decided in 2017 by the ECJ. The court stated that it is in the public interest to collect personal data for the purpose of combating tax fraud. We therefore submit that there is indeed proper legal basis in this case. Your Excellency, with respect to the second claim, where we will now address, Your Excellency, the requirements of fairness and transparency raised by the applicant, but misconstrued as understood before this honorable court. Your Excellency, the first issue under the second claim is whether FGN has violated the NDPA. The second is whether FGN has infringed on Mr. John Coe's copyright. Again, Your Excellencies, this issue requires the application of the NDPA and the Copyright Act. And as we have submitted, these laws are not applicable before this honorable court. But in any case, we argue that all these conditions are met. Firstly, Your Excellency, we note that unfortunately, the agents for the applicant misunderstood the data specification principle for the requirements of fairness. They have argued that because the data protection, because the presidential directive in this case has no clear purpose, no clear scope or purpose, it means that the data specification principle has been breached. But this is a clear misunderstanding of the fact. The only thing that does not have a clear scope or purpose, Your Excellency, is not the reason for the collection, but the law that permits the collection, Your Excellency, as stated in paragraph 4 of the company. Therefore, we submit that there is no breach of the data specification principle. Rather, it is only the law that requires the processing that does not have clear scope and purpose, Your Excellency. Your Excellency, furthermore, we note that they argued relying on section 24 of the NDPA to argue that the fairness principle has been breached. But this argument is also misconceived. The applicant had failed to provide any legal authority before this honorable court on this issue. They have failed to cite any legal authority. Your Excellency, they have failed to cite any judicial authorities. They have failed to substantiate the claim. Their mere assertion is that the people of Kembari had been discriminated against. However, this argument is illogical because a similar claim came before the US Supreme Court in the case of Loomis versus State. where the states are deployed Compass, an algorithm that is capable of detecting people with high possibility of committing crimes in the future. The court stated that in that case, the relevant thing to note is whether the federal government, the state, has an intent to discriminate against the people. There is no such intent in this case. The discrimination is entirely based on historical facts, and an algorithm would always find historical facts that are available on social media. As such, the federal government of Nigeria was not responsible for the discrimination. It is because it is an historical fact, and there is nothing that could be done. Your Excellencies, we therefore submit that the fairness principle was not violated. Your Excellencies, they also argued that there was algorithmic bias that is based on the fairness principle. And as we have submitted, Your Excellency, this argument is flawed, and they have no relevant argument before this honorable court in that regard. Your Excellency, lastly, with respect to the issue of copyright, it is saddening, Your Excellency, that the applicant believes that personal data are copyrightable materials. The personal data that were collected in this case, as seen in paragraph 9 of the complaint, are Mr. John Scholes' home addresses, telephone numbers, social preferences, and hobbies. Your Excellencies, these are facts. Facts are not copyrightable materials. Your Excellencies, we rely on the locus classicus case of Fees Publications Incorporation versus Rural Telephone Services, where the court stated that facts are not copyrightable. The facts in question in that case include names, telephone addresses, and phone numbers. Therefore, we submit, Your Excellencies, that Mr. John Scholes' personal data are not copyrightable in the first place. And if there is no copyright, there can be no infringement. But in any case, Your Excellencies, we engage their argument with respect to whether his article published on Jankara Reporters had been used, had been an infringement of his copyright because it was read by Capture-It. But this is also, Your Excellency, a misunderstanding of the fact. As at the time that Capture-It read Mr. John Scholes' article and profiled him on that basis, it had already been trained. Your Excellency, Capture-It had already been trained by data sets known as training data. And at that point, Your Excellency, his article was not used as a training, Your Excellency, for Capture-It rather. Rather, it was Capture-It only assessed that article and used it to profile him as a potential terrorist. We note that the fact that Capture-It relied on that article does not mean his copyright has been infringed, because Capture-It was not trained with that particular article. And as such, we submit that Mr. John Scholes' copyright was not infringed in the present case. Your Excellencies, again, back to the issue of fairness. We note that I beg your pardon, Your Excellency, back to the issue of transparency. We note that the applicant argued that there was no transparency in the present case, although the argument is a misconception of the difference between data specification principle and the requirement of transparency. We have, however, note the Article 29 Working Paper Party guideline, which states that with respect to transparency, the information relied upon by the algorithm must be publicized. However, Your Excellency, respectfully, this concludes our submissions on the merits, and agents will respectfully invite his co-agent to address this honorable court if there are no further questions.
Yes, any question? Let's take the virtual panelists first so that we do not forget them. Any question from the virtual panelists? Let me ask though, you've asked us to reverse our earlier decision. Why do you think we have the powers to do that? And if we must do that, what should we consider?
Most obliged, Your Excellency. We understand your concern. However, this court is an international court, and it is not bound by the principle of judicial precedent. All its decisions are only persuasive and not binding on this honorable court. Therefore, where the principle of international law is clear, we urge this honorable court to follow a similar path, Your Excellency.
Yes.
Okay, thank you.
Yeah. Can I quickly ask a question?
Please go ahead.
Yeah, so along the lines of what the President has asked, I noted that you, on the issue of, was it on admissibility or exertion of local remedies, you asked the court not to disregard its previous decisions. My question is, can you distinguish this particular case, from those other decisions, or on what basis are you asking the court to disregard its previous decisions in this regard?
Yes, Your Excellency. Respectfully, our basis, Your Excellency, is consistent with customary international law, Your Excellency. We note that exhaustion of domestic remedy is a customary international law principle. And pursuant to Articles 19 of the ECOWAS Protocol, this court can rely on customary international law. With respect to the decisions relied upon by the applicant, particularly the case of CDCAN versus the Gambia, this honorable court stated that Article 10D of the ECOWAS Protocol does not require the exhaustion of domestic remedy. And that was the basis for the decision. But then, Your Excellency, the ICJ has stated in a plethora of cases that for a customary international law principle to be waived, there must be an express provision that says so. Since Article 10D of the ECOWAS Protocol does not say exhaustion of domestic remedy is not a compulsory requirement, we submit that since it is a customary international law principle, it applies by default, Your Excellency. And we urge this honorable court to reverse its decisions.
Yes.
I hope that answered your question, Your Excellency.
Okay, thank you very much.
Thank you, Your Excellency.
Thank you. So,
Your Excellencies, please, I want the agent to clarify his allusion to necessity of the action of the government. Could you clarify that?
Yes, Your Excellency. Absolutely, Your Excellency. Your Excellency, with respect to necessity, the requirement is that there must be no other means of achieving the purpose in question. We note that the particular purpose in question, Your Excellency, is the protection of national security and the investigation of crimes, Your Excellency. And that was the main reason why the president issued the presidential directive, as seen in paragraph 3 of the complement. But first, to do that, we need to harmonize our database and collect personal data for the purpose of intelligence. But the only way to achieve this means, Your Excellency, the only possible way of identifying these criminals who are destroying the lives and property of our citizens is to interfere with their right to privacy to a considerable extent, Your Excellency. And that mandated the deployment of capture rates, which was used to gather personal data and also to check their private communications, Your Excellency. And it was the only means possible because of the anonymity that social media and other online platforms offers, Your Excellency.
So
sufficiently answer your question, Your Excellency.
Was the measure directed to the entire populace where you can now, upon distilling the process, you now identify the terrorist or the potential terrorist, or it was targeted at already identified terrorists? Is it a general measure?
Your Excellency, we understand your concern. However, our action was not.
Please just answer the question. Is it is applied generally, right?
Not necessarily, Your Excellency. According to the fact, it was particular to potential political activists that were deemed as troublemakers, Your Excellency, within the territory of Nigeria, and not to the general population. The only thing with respect to the general population is the collection of the data for a national database.
All right. Please, because I don't have the facts now, but is there a right of objection or clarification from the other side so as to be able to clarify these key points on whether it was directed to the general public?
I think they'll have right of replies.
Yeah, so please clarify that. Yeah.
Yes. You've taken that, the applicant, on your right of reply. Yes.
Thank you, sir.
okay, thank you, Agent. So in line with the thought of one of the questions that were asked, so when you said the federal government of Nigeria needed to get those information based on confidentiality and the sensitivity of that process, so do you have submissions to clarify the basis why the platform custodian was not properly notified, even though if you don't want the general public to know, you don't want to seek their consent. So the platform that owns the data, that controls the data, do you think they are supposed to be properly engaged?
Yes, of course, Your Excellency. But there is nothing in the fact that says Light Touch Incorporation was not aware of the data mining, Your Excellency. And since it is a secret affair, as recognized by the Terrorism Act, the Cybercrime Act, and the lawful interception of communications regulation, Your Excellencies, we respectfully submit that Light Touch Incorporation must have been aware of the collection, Your Excellency. The only people who were unaware must have been the general population.
Thank you. So my second question is around the transfer of data between the federal government and the Gambian government. So you referred us to a foreign law when you were trying to back that up. So are there no local requirements for the federal government that they should have followed on that, instead of you referring to the foreign laws?
Your Excellency, respectfully, that is the third issue, which will be addressed by my colleague.
Addressed by the second.
However, it is our contention that the NDPA was complied with in all key respects, particularly Section 41 and other relevant provisions. Your Excellencies, are there further questions? Thank you.
Okay, so with respect to the alleged infringement of copyrights, so what evidence do you have before this court to demonstrate that the capture rate was not trained with the article of the applicant?
Thank you, Your Excellency. We refer this honorable court to paragraph 5 of the compromise. It says the capture rate can pull information from any source, including social media, and cross-reference it, Your Excellency. Also, in paragraph 9 of the compromise, we see that the information collected by capture rate for the training, Your Excellency, for the purpose of, for the data mining, Your Excellency, are telephone numbers, social preferences, and addresses, Your Excellency. As at this point in time, capture rate was already trained. It was already capable of detecting potential terrorists, as seen in paragraph 12 of the compromise. Some activists were already detained because of their affiliation with potential terrorists, Your Excellencies. But Mr. Johnsko only published in his article in paragraph 13 of the compromise. As at that time, capture rate had already been trained with the relevant data sets, and it only flagged the Jankara reporter's article. And it was not trained based on this data, Your Excellency. It was not trained based on this data, according to paragraph 13 of the compromise, as it was already capable of identifying potential terrorists. And the issue requires that whether Mr. Johnsko's copyright has been infringed because it has been used to train capture rate. But since it has not been used, Your Excellency, there is no infringement.
Any other questions?
So one more question. So can you throw more light on your allegation that the purported violation of the principal specification is untrue? Because according to what you said, you specifically made reference to the acts as not being adequate enough to provide for the scope of collection in the first instance and not the facts. So please, can you provide clarification in that regard?
Your Excellency, I really understand your concern. If I may refer this call to paragraph 4 of the compromise. It states that the president issued a presidential directive. And the fact says the presidential directive had no clear scope regarding the kind of information to be collected or what the information was to be used for. However, with respect to the data specification principle, it says processing must be explicit. The data collected must be specified, the reason for their collection, and it must be specified and explicit, Your Excellency. But the law, it doesn't say the law that mandates the collection should be explicit and specified. It only says the processing and the collection must be specified and explicit. In the present case, Your Excellency, there is nowhere in the fact that the NSA had no specific intention to collect certain data, Your Excellency. But in any case, it is our contention that the data specification principle should also be read alongside the next principle, Your Excellency, which is that the data collected must be adequate and must also be sufficient for the purpose of the collection, Your Excellency. In the present case, there is nowhere in the fact that the reason for the collection or the data collected are not sufficient or sufficient for the purpose for which they were collected. As such, Your Excellency, we argue that this court should read those two provisions together alongside the fact to find that there was no breach of Section 24 of the NDPA.
Thank you. Any other question? We will now hear from the second agent for the respondent. Thank you.
Thank you so much, Your Excellency.
You may proceed.
Mr. President, Your Excellencies, may it please this honorable court. Announcing appearance before the bench is Tiwalade Adekile, and as earlier introduced, I am co-agent for the respondent in the matter before this court. In the next 15 minutes, agents will address claims C, D, E, and F on the justification and legality of the actions of the respondents towards the applicants. With your permission, Your Excellencies, I will now proceed to make my submissions.
You may proceed.
Most obliged, Your Excellencies. On claim C, the applicants have conveniently anchored their arguments on the existence of data laws in the recipient country, the Gambia. But we find, Your Excellencies, that in order to establish our submission, that the federal government of Nigeria complied with the provisions of the NDPA 2023 when it supplied the personal data of Mr. Jones School and others to recipient country, the Gambia, we find it necessary to bring your attention to sections 41 and 42 of the NDPA, which provide for the conditions of cross-border transfer of personal data. In mentioning section 41, the applicants argued that the Gambia, the recipient country, according to paragraph 11 of the facts, does not have a data law. But they conveniently left out the fact that the section also states that they must be able to provide adequate levels of protection for personal data that they intend to receive. Your Excellencies, the question then that is raised is, does the Gambia provide adequate levels of protection for the personal data of Mr. Jones School? One of the features of adequate levels of protection is provided in section 42 of the same act as being a party to binding international conventions. And the NDPR 2019 implementation framework clearly provides the answer to this question. In that provision, the annexure C of that provision, a list is titled countries deemed as having adequate levels of protection to receive personal data from Nigeria. On that list, the first is every African country that is a signatory to the Malabo Convention on Data Protection of 2014. The Gambia is one of such countries. Our argument, Your Excellencies, is that the NDPR, and by extension, the NDPA, was complied with by the federal government of Nigeria in supplying the personal data of Mr. Jones School to the Gambia. Furthermore, Your Excellencies, paragraph 11 of the fact states that this personal data was not supplied with Mr. Jones School's approval and consent. But we bring to your attention section 43 of the NDP that states that in the absence of adequate levels of protection, the subsisting conditions would apply. One of them is the unwithdrawn consent of the data subject. Our argument here, therefore, is that there is no need to comply with section 41 and 43 to be satisfying the conditions of total compliance with the NDP. By ensuring that the Gambia does have adequate levels of protection based on the NDPR implementation framework, the federal government of Nigeria did in fact comply with the NDP. Furthermore, the applicants have left out the fact that in paragraph 11, it is stated that the federal government of Nigeria pseudonymized the personal data of the applicants, protecting their identities. Section 39, section 1 of the NDPA provides that pseudonymization is an appropriate organizational and technical measure to ensure security of the identity of data subjects. Based on this, Your Excellencies, we argue, contrary to the submissions of the applicants, that the federal government of Nigeria did comply with the provisions of the NDPA 2023 when it supplied the personal data of Mr. Jones School to recipient country, the Gambia. On the next claim, Your Excellencies, issue D, that Light Touch Incorporation failed in its obligations to the applicants when it allowed the federal government of Nigeria mine its platform for their personal data. Your Excellencies, the applicants have argued that they failed to take appropriate measures to protect the personal data of the applicants. But our arguments, based on Article 43 of the Supplementary Act on Data Protection within ECOWAS and Section 24 of the NDP, is that data controllers must take necessary precaution to ensure that their the personal data in their custody is inaccessible to unauthorized third parties. Furthermore, Section 24 of the NDPA mandates that organizational and technical measures must be put in place to ensure the integrity, confidentiality, and availability of said data. Your Excellencies, Section 39, subsection 2 of the NDPA recognizes encryption protocols as an appropriate organizational measure mentioned in Section 24. Hence, when in paragraph 8, Light Touch Incorporation declared that it put in place state-of-the-art encryption protocols to protect the data in its servers, not just from unauthorized third parties, but from even its independent subcontractors, the first respondents, so that they do not have indiscriminate access to the personal data of data subjects. We argue that it was a measure taken in this step to protect their personal data pursuant to Section 24 of the NDPA and Article 43 of the Supplementary Act on Data Protection within ECOWAS. We further argue, Your Excellencies, and put before this court humbly that the Terrorism Act of 2022 in Section 68 empowers the NSA to intercept communications of citizens to pursue and investigate terrorism. Your Excellencies, the third and fourth respondents being subject to the government of Nigeria for the processing of personal data of Nigerians would have to comply with the provisions of these laws and submit themselves to the obligations, to the public law obligations of the federal government. It can therefore not be held that they failed in their obligations to the applicants in compliance with the laws of the federal government of Nigeria. Your Excellencies, we argue, contrary to submission of the applicants, that the Light Touch Incorporation, the third respondents in this case, did not fail in their obligations to the applicants. On claim E, Your Excellencies, the Light Touch Incorporation we submit was justified to refuse transfer and to retain the personal data of Mr. Jones Cole on its platform. Your Excellencies, the applicants have argued threefold. They first argued that Mr. Jones Cole was denied the right to data portability. Second, they argued that the request for a fee was a hindrance to his rights on data portability. And third, they argued that the erasure of his personal data was something that Light Touch Incorporation was obligated compulsorily to comply with. Our submission on in response to the argument of the applicants on this is that first, Mr. Jones Cole was not denied transfer, but he was offered a conditional measure of transfer based on his payment of administrative costs and fees for that transfer, as clearly outlined in paragraph 14, when Mr. Jones Cole approached Light Touch Incorporation. Your Excellencies, in the case of Digital Rights Lawyers Initiatives and NIMSI, the court held where the applicants had brought a case a matter before the court on the issue that requesting an administrative fee for the rectification of wrong data was a hindrance to their right to data privacy under the Constitution. The court had held that requesting an administrative fee is in no way a hindrance to that right by a service provider. Furthermore, Your Excellencies, the CJEU has held, in the case of X versus X, that where a law does not state outrightly that a fee should not be required for the performance of a service, requesting such fee is not unlawful in that circumstance. Hence, we argue, Your Excellencies, that first, they were not denied the right to data portability, but it was conditional on administrative fees being paid. And such administrative fees are not a hindrance in any way based on earlier court decisions and are not a ban or illegal with respect to the NDPA or the Supplementary Act. On the third part of that argument, that the Light Touch Incorporation was wrong in stating that it could retain their data, we bring your attention to paragraph 13 of the facts, where it states clearly that Mr. Jones Cole was arrested and charged for the crime of terrorism. Your Excellencies, we admit that Section 34 does provide for the right to erasure of personal data, but we also want to state that Section 34 states an exception, that they may retain personal data on a lawful basis. The question here is, what is the lawful basis of Light Touch Incorporation retaining Mr. Jones Cole's personal data? We bring your attention, Your Excellencies, to provisions of the Terrorism Act, that allows, of the Cybercrime Act, that empowers service providers, the Cybercrime Act, Your Excellencies, to keep subscriber information of data subjects. Furthermore, Your Excellencies, in the case of Bonia Audios and Perfect Communications, the court held that service providers have an obligation to retain data and make it available for investigation, detection, and prosecution of serious crimes. Your Excellencies, terrorism is a serious crime, and Mr. Jones Cole has not been declared not guilty of that crime. Hence, they reserve the right to retain his data. On the final claim, Your Excellency, that the National Data Protection Commission is independent as required under relevant law. The applicants have argued, Your Excellencies, that their independence hinges on the ability of the president to appoint and remove the commissioner. But we bring before you, Your Excellency, that the facts of this case have nothing to do with the president in any way whatsoever. They have stated, Your Excellencies, that the response of the NDPC was too brief to consider it independent. Your Excellencies, in paragraph 15 of the facts, when Mr. Jones Cole approached the NDPC, his complaint was referred to it, and according to section 46 of the NDPA, the commission may investigate complaints referred to it. Upon their findings, they responded that it was a national security matter. These findings were before any consultation whatsoever. They had determined that this case was not theirs to investigate. And based on section 46 of the NDPA, which says that they may investigate, their ability to or not to investigate is an expression of their independence. We urge this court not to base its decisions on one man's subjective disappointments and thoughts, as provided in paragraphs 15 and 16, that the NDPC is not independent. We further provide this court with several provisions of the NDPC that provide for the practical independence of the NDP. Section 19, Section 56, Section 57, that provides for funding from the Consolidated Revenue Fund so that they do not subject to the whims and caprices of other members of the executive, as stated in Article 16 and Article 17 of the Supplementary Act on Data Protection within ECOWAS, which states that they must be immune in performance of their functions from the instructions of other members of government. Furthermore, Your Excellencies, Section 56 that restricts suing the members of the commission, and Section 57 that indemnifies them in where liability on personal basis is concerned. Your Excellencies, our argument is that the NDPC is independent as required under the Supplementary Act on Data Protection, which also provides in Article 22 for budgetary allocation to data authorities within member states, and also within the context of the NDPA. We argue, Your Excellencies, that the NDPC is independent. We hereby, Your Excellencies, adopt our prayers as provided on page 32 of our memorial, and we urge this court to maintain the standard of justice it is known for in ensuring that a sovereign nation's attempt at preserving national security and fostering economic integration as recognized by this community is not undermined by the claims of the applicants on the violations of human rights, which are clearly non-existent. Much obliged, Your Excellencies. We hereby open ourselves for questions by the panel.
Virtual judge, the panelists that have joined virtually, yes.
All right. Thank you, Lord and Your Excellencies. Agents, I would like you to explain further on the issue of the technical and organizational measure. You cited the issue of encryption. Are there other measures put in place apart from encryption? Thank you.
Yes, Your Excellency. Another measure stated by Section 39, subsection 1, is pseudonymization. Encryption protocols, pseudonymization, and any other measures provided by data controller or data processor. The Act does not state that they must be all of those procedures or measures put in place at the same time. It just states that in subsisting subsections of that section 39, any of the measures taken in line with pseudonymization or encryption protocols, which you see in paragraph 8, that Light Corporation took, would be an appropriate organizational and technical measure to protect personal data.
And, okay, and that means, in your opinion, encryption alone, without more, will be adequate and in the eye of the law?
In the opinion of Section 39 of the NDPA, Your Excellency, it will be adequate.
All right, thank you.
Yes, Your Excellency.
Nothing from me.
Yes, Your Excellency.
So, on the issue of the condition for transfer that was given to the applicant. So the applicant was given condition to have the data transfer. So those conditions, do you have facts or clarification to this court, whether these were made known to the applicant before getting to the platform and consented by the applicant?
Your Excellency, are you asking whether the facts state that the government made the transfer to the Gambia known to the applicant?
No, not the Gambia now. So the transfer of the Mr. Jones data from from the platform to another platform, from the request. So the condition that was made known to the applicant for them to have the data transfer from their platform to the other platform, was it made known to the applicant and consented by the applicant?
Your Excellency, it was made known in paragraph 14, and I quote, Your Excellency, they stated that if such a request were to be granted, it would involve paying a fee. The applicant—
Was it made known before the applicant got to the platform and consented by the applicant?
Okay, Your Excellencies, the facts do not state the contractual relationship of the applicant and Light Corporation. But based on the findings of the holdings of the court in Digital Rights Lawyers Initiative and NIMSI, requesting such fee, where it had not previously been made known, also in that case, to the applicant, NIMSI had not made it known that they would require a fee to rectify issues with personal data. The court held that requesting administrative fee is not a hindrance to the exercise of the right to data portability.
Thank you. So my second question now goes thus. The FGN, for the transfer of data to the Gambia, you have alluded to this court that the FGN actually complied with the NDPA for doing that. Okay, so are there provisions in the NDPA that is required for the recipient of the data transfer?
Your Excellency, the provisions required are Section 41, which states that they should be subject to data law and they should all be known to have ensured to afford adequate levels of protection. So the requirement on the side of the Gambia is that they have adequate levels of protection and the data law. The applicants have pointed out that they do not have a data law, but failed to point out that they fulfill the other requirements of having adequate levels of protection by virtue of the fact that they are parties to the Malabo Convention on Data Protection within ECOWAS, which is recognized by the NDPR.
Thank you.
Most obliged, Your Excellency.
Any other questions?
Okay, so I see that with respect to justifying the cross-border transfer, you have relied heavily on the NDPR. So can you educate us on the utility of the NDPR, particularly considering the emergence of the Data Protection Act?
Sorry, Your Excellency, on the utility of the NDPR, particularly considering
that, because it's a later in time law.
Oh, yes, Your Excellency. Section 63 of the NDPA states that previous regulations, rules, and policies made with respect to data protection before the emergence of the NDPA would still apply, except outrightly cancelled or banned by a following policy, regulation or law, Your Excellency. So the NDPA endorses the NDPR and still ensures that it's applicable.
The second question is with respect to the allegation of independence.
Yes, Your
So you relied heavily on some of the provisions of the Act just to demonstrate to this honorable court that indeed the Data Protection Commission is independent. Is there anywhere under the Act where the Data Protection Commission is required or allowed to consult other governmental agency in indeed reaching the findings on complaints lodged before it?
Your Excellencies, in the NDPA does allow the NDPC to, when complaints referred to it, approach or investigate the complaints referred to it and the subjects of those complaints. In investigation, it may be necessary to approach subjects of those complaints to ascertain the true nature. As known, Your Excellency, is one of the the foundations and the principles of fair hearing is that both sides must be heard by whether it is an administrative tribunal or a court of law. We argue, Your Excellencies, that the ability to investigate by Section 46 covers the actions of the NDPC in approaching the subject of the complaints, Your Excellencies. Your Excellencies, our argument is twofold on the obligations to the applicants. It is first that they did fulfill their obligations by putting in place those encryption protocols as Section 39 to Section 2 recognizes as adequate, and that where they are obligated to the national government of that country to provide information or to make their platform available, where in this case, the federal government embarked on a database management exercise to collate for the purpose of national security, they will be subject to those obligations and laws to the national government. So our argument is that by putting in place encryption protocols, they did not fail in their obligations to make it inaccessible to third parties. It wasn't even accessible to Let's Go Consultancy Africa. But they do have an obligation to national governments and to domestic laws to ensure that, as is stated in Section 24 of the Act, that they ensure the integrity, confidentiality, and availability of personal data. So to make it available, Your Excellencies, to the government.
Was it made available to the government or the government intercepted?
The government has the power, Your Excellencies, to intercept based on the Terrorism Act and the Legal Interceptions Communications Regulation.
Thank you. Any other virtual? Yes. Let's take. Okay, you may sit down and we are satisfied with the responses provided.
Most obliged, Your Excellency.
Yes. Okay, okay, maybe we'll take that question in the replies. Applicant, you want to start with your replies? Registrar, how many minutes do they have for their replies? 5 minutes, yes. So you use your 5 minutes very well. So go straight to the point.
Mr. President, Your Excellencies, once again for Team 22, Olaposi Inioluwa, lead agent for the applicant. And having listened to the submission of the agents for the respondent, we are indeed embittered that they have not only misconstrued the purposes of the law, but manipulated the facts of this case. Your Excellencies, they have indeed submitted, based on local laws, that this court should have no reference to such. However, they have only said this with their words and departed with their actions. To set things straight, we make reference to the provision of Article 2 of the 2010 Supplementary Act on Personal Data Protection within the ECOWAS. Your Excellencies, this article provides that each member state shall create a legal framework for the protection of privacy within their countries. It is pursuant to this law that Nigerian has established the Nigerian Data Protection Act. Your Excellencies, stating before this honorable court that the court cannot make reference to these local laws is like stripping a nursing mother of his child. Your Excellencies, the respondents, even in their case, have not only made mention of the NDPA, but have quoted sections of the NDPR also, stating that they have only looked on the crumbs in our eyes while they have logs of wood on their own eyes. Your Excellencies, going to the issue on jurisdiction, we wish to state before this honorable court that we are not unaware of the levels of jurisdiction that are geographical, material, temporal, personal. However, Your Excellencies, why kill an ant with a sledgehammer? We know that we are restrained by time and cannot identify each component of jurisdiction one after another. However, we have gone with the purposes of the law in the pursuant of justice, as it has been established in the case of Reverend Solomon MFA and 11 others, that the claim of the appellant shall determine the jurisdiction of the courts. Your Excellencies, the claim of the appellant in this case is relating to human rights violation. And that is exactly why we have quoted the section of the law in Article 9-4 of the Supplementary Protocol. Your Excellencies, however, if we may wish to dance to the tone of the respondent, we would like to quote the article in Article 5 of the Revised Treaty of 1993, which established that before this court, corporate bodies can appear. Your Excellencies, corporate bodies. And corporate bodies is established by Section 823 of CAMA 2020, as including non-governmental organizations. The second respondent in this case, Your Excellency, we do submit that there is indeed jurisdiction. And for the second respondents, we make mention again the first principle of law, actios popularis, giving them the right to bring an action in a representative capacity, as they have so done. On the principle of assertion of local remedies, we are further embittered that the respondent has manipulated the purposes of the law. This court, this honorable court, as we have said, has held in plethora of cases that the requirement of assertion of local remedies is not necessary in human rights violation cases. Why? We deem fit that your lordships, your excellencies, your learned brothers have thought it wise that of the sacrosancy of human rights violation matters. Human rights violation are special matters and cannot be treated like any other matter before the court. Your Excellencies, we don't submit that this court should not depart from an age-long principle that has borne on its shoulders the principles of justice established in plethora of cases, including the 2017 case of La Society versus the Republic of Mali, that assertion of local remedies is not necessary for bringing an action before this honorable court. Moving on to copyrights as it relates to personal data. Again, the respondent in this case has misconstrued the law in defining what personal data is. To make things straight, we make reference to Article 1 of the Supplementary Act of 2010, as well as Section 65 of the NDPA, providing for the interpretation section. And we say that copyright has been, personal data has been defined as meaning any information relating to an individual. Your Excellencies, lastly, related to national security, we want to clarify before this honorable court that it has been held in both local and regional courts. Now, when it relates to national security and the departure from human rights of the citizens, the court shall make reference to whether or not there is an immediate threat of national security. It is either there is a threat of national security or there is a likelihood of a threat before the court can depart from human rights. It has been so held in Dokubasari versus Federal Republic of Nigeria and media rights agencies and others versus Federal Republic of Nigeria, a case before the African courts. Your Excellencies, we have many points of rebuttals and we can go on and on and on. However, we have restrained ourselves to this point based on the time allocated. Lastly, Your Excellencies, from the cave to the computer, from the Homo sapien to the Homo sapien, it has been the honest pivotal fulcrum point of the law that the court will do justice. And Your Excellencies, justice cannot be said to be done if a reasonable man leaves this court thinking the judge was biased. We thus plead, Your Excellencies, to do justice. Do justice, even if heavens fall. Fiat justitial, rat coelum.
Thank you. Any question in the reply? No, you may.
Okay, thank you. Okay, please go ahead online.
Sorry, I didn't, Your Excellencies, I didn't get any clarification on the nature, on the scope of the measure. Is it really directed at identified terrorists, or it is it is a widespread measure? It applies broadly in the society, whereby after seeing the facts, then they would now know that this person is a terrorist. What is the fact? The method used for data processing, it applies to the entire members of the public, or to terrorists?
Thank you very much, Your Excellency. It applies to every member of the public, as
All right.
opposed to what the respondent would have said.
All right, thank you very much.
Thank you very much. That is the fact in the case.
Yes, any other question? Thank you. We are satisfied. Yes,
It has been an
yes,
honor arguing before this honorable court.
Thank you.
As a matter of fact, I cannot but just say, wow. This has been a very, very wonderful arguments, appearances from both the applicants as well as the agents for the respondent. I think they deserve a robust round of applause. I am so very sure that even some of our lawyers cannot do better than this. Can we give them another round of applause? Well done, guys. Well done, guys. Well done, guys. We have come to the time of decision. Oh, allow the, okay, you have something to say. We will give them feedback, but you see, collect our result for us first. When we have our results, and because the other result also that we collect at our end here. But when you give us your result here, and we are collecting our own as well. I mean, those other ones that are not related to the final matches here, then you can give them feedback. We'll use that time to give them feedback while we do our stuff down there. And when we are done, and you are done with feedback, then you come and announce the winner of the match, as well as the other prizes that are at stake. Thereafter, Milord Oshodi, Celestina Wabwese, and my very good friend and longtime partner, Mr. Sodi Bello, will present the different prices, and then we'll call it a day. So the procedure is this. The judges are compiling the result now for this particular match. When we receive the results, we'll go and do collation for the other prices and positions while they give feedback. So by the time they give the feedback, yes, sir.
I would still like to make some remarks. I didn't actually
Yes,
want
sir.
to
Yes, sir. You
prejudice
make remarks. That's what I'm saying. When we get results from the
yes,
yes,
exactly,
you can start making your
exactly.
remarks while we do
All right.
collations there. When we are done, then we'll come back to announce the results. So that's the way.
It will be better to have the results ready.
Yes,
so that whatever I
will
say will not prejudice. I mean, will not weigh on
the judges. They are already drawing up their results, sir.
All right, thank you.
Yes, yes. So we just give them 5 minutes to score the teams, and then give us the results, and then you can give your feedback. And then we'll come back to announce the winner and the other prizes as well. Thank you very much, sir. Educator Malam. The only one.
Seriously, I must commend everyone here today. I now see the reason why I was asking myself, with this panel and so many things, why didn't I end up in law? Can see some raw things coming out from one or two, and like, God. The single ladies and gentlemen deserve a round of applause, please. Put their hands together for them. Now I see most, I do not have any other department, any faculty here apart from law. What department? Medicine. Wow, please a round of applause for her. And I believe you will love to actually pick a second degree in law. Right? Aksa now, you love exactly what happened here, right? You like it. Wow, please a round of applause once again for her. So this is exactly what you go in the Faculty of Law to carve out. No wonder the finest girls you find in Faculty of Law. You find the most beautiful girls on campus on the Faculty of Law. But put your hands together, celebrate the Faculty of Law, please. But does not have time for relationship. Now I know because of those criming, those things. You're from the Faculty of Law, ladies and gentlemen, put your hands together for yourself. Now, on this note, I want to talk about some sentences. University of Lagos is a ground for you to build up. If you like, they will tell you, while we comes in 20 sometimes ago, it's exactly what you start with, you graduate with. Imagine I start with third class. Will I be able to get a first class at the end of the day? No. Is it possible to start your CGPA with third class and come out with first class? Whatsoever, the way you lie your bed, you sleep. So that is why I announce some certain people, if they fail to make it in other way, I'll get the way they were talking, I just get envy of them. Like, can I talk like this? Listen, ladies and gentlemen, they really try. Put their hands together for them once again. Seriousness in the faces of beautiful girls of law. If we see them in the faculty, most of them, they're always in Moremi. Anytime they come with their black and white stuff, they are always serious. And do you know they are the first to start exam before any other body? Happy now? So that they're able to remember some of these things they actually learn. Now let's look at University of Lagos. Those that graduated with first class always come with first gate, Abi. Those that graduate with second class come from where? Second gate. Those pass. How many of you know what third gate in Unilag now? Lagoon front. So those that graduated with third class and pass will not have a way to, if the first class block the first gate, second class block the second gate. You know, those that graduated with third class and pass will be coming through Lagoon. How many of you know that? You carry boats, you fly boats, and some sentences, your mommy and everybody. So it's encouraging. My own duty is here to encourage you. If you're on a kind of way, you can actually boost so many things. I can tell you there are beautiful girls on the campus of the University of Lagos. And I want to authorize on the hostel. Now, hostel is superb. They provide everything for us to actually enjoy. And how many of you in Moremi? There is a particular hostel. Sorry, sir. There's a particular hostel on the campus of University of Lagos. They are far away. I don't know, they call them Mosquito Island or whatever. If anytime you see them walk, let me just start from the top. You know the top hostel in Unilag. Anytime they walk is dollars, pounds, dollars, pounds. Which hostel is that, please? Someone say Moremi, I don't know. There's another one on the campus of University of Lagos. Anytime they walk, 1,500, 1,500, 1,500. Which hostel is that one? I didn't say that. There's another hostel on the campus of University of Lagos. Another hostel on the campus of University of Lagos. Anytime they walk, it is 1 naira 50 kobo, 1 naira 50 kobo. Which hostel is that? I didn't say so. Another one on the campus of University of Lagos. I don't know whether because they are far away, they are close to wire. I didn't call any hostel. But anytime this hostel begin to walk on the campus of University of Lagos, Any amount, any amount, any amount, any amount, any amount. Which hostel is that? It's on this snow, ladies and gentlemen. I want to encourage you. No matter what the platform given to you, make sure you utilize it and utilize it well. And I see you on the top. Father, during our time, you see anything? Duh. Even the boys too, don't they do duh for hostel? How many of you know that? Duh. Winge, bladder. I hope those things have gone. Then in the year 2019, did I say 2009, 08, 05, they used to categorize Unilag girls as, do we still do that? I could remember far back there exactly when they want to change the name of University of Lagos. They changed it to Maulag. You know who now start to claim Unilag? FC is saying that them be Unilag now. Put the hands together for yourself, please. You know, no matter how you find, no matter what comes your way on the campus of University of Lagos, try it as much as possible to utilize the time given. Try it as much as possible to learn from others. Try it as much as possible to actually abide with the law, read your book, and the sky is your limit. I can remember I didn't have opportunity to go to a public school, private school. I finished from a public school that actually make me a public announcement. Far back then in the school, I went to a kind of a school. Should I tell the name of my primary school? Ajaleko Nursery Primary School. How many of you went to the kind of school I went to? The kind of school that we remember the song we sing back then were like, Batarea ko. So many of my schoolmates are here. Batarea ko. I know this man was giving me a nice voice. Hey, Batarea do come ka. Batarea do ko. To my kind of school again, we have opportunity to go to school where they do wherever you go. So you went to my kind of school too. Is it Ajaleko school 1 or school B? No. Let's look at this. Is this school 1 or school 2? Oh, yeah. Can you sing the song for us? Wherever you go. Whatever you see, do not say yes. Your voice is as sharp as anything. Wherever you go. I laugh, self, they make my laugh. Put your hands together for her. Oh my God. You know, during that time, school is fun. School is fun. I finished, Dr. Sir, about 10, 15 years ago in Unilag. And I'm proud to actually, immediately, they said, make people like us no go. We retain us on Unilag FM. Put your hands together for yourself. This is my time. And my word for you is today is, whatever you're going to be in life, has to do with your daily activities, whatsoever you put together every day. Don't go and rip corn when you plant beans. So if you plant corn, the way you lay your bed, sir, doctor, the way you lay your bed, so you lie. So I wish you all the best. I wish you all any area you don't understand in the aspects. If you want to talk to be like them, if you want to be like them, there are opportunities for actually to learn. If you're year 1, year 2, some of you may imagine that, is this what I'm going to be facing? Will I have opportunity to talk? Like to talk. How many of you can talk? I noticed when you were writing, you were jotting some things down. Put your hands together for her. She might be a good, I call it debate. Public school, during that time, now public school, private school. Now you take the private school, I take the public school. Put your hands together for her. Put your hands together. I can see the eloquence and the way she was busy jotting things down. Celebrate her once again. See, a little bit shy, and I'm going to be giving you 1 or 2 points on what we do during our time. When you get to time of work, you go now like, you know, you can't have a Jepota can they compete with us for during our time. Good morning, panel judges. Good morning, accurate debater. Good morning, this. You go see them, the doctor. Bounce. When you reach out, good morning, panel of judges. Good morning, accurate debate. Good morning. Good morning. I've done great finish. Why did you turn go talk? Don't go. You know, why you're talking like that, the sound engineer will be like, yeah, what's wrong? But boy, they make a point. See, please connect the thing, put it. At the end of the day, they will mix what is right and go and put it in another jack. You understand? But when they get to that with this following point, now our microphone they always on. With this following point, I'm here to convince you. Where did be the point right up to? With this following point, I'm here to convince you that private school is nothing compared to public school. Put your hands together for her. You're still clapping while you're not talking. Put your hands together for her, please. We're going to give a topic and somebody's going to debate. Oh my God, are you still hitting the leg? I thought you done hitting the leg now. You know, let us look at it generally. Did you have intention of actually coming into law when you're in primary school? I love the vibe from. Did you have intention from primary that you're going to read law? Sure. How about you? No. So what's your dream course when you're actually coming? Panel, am I free, sir? Honorable sir, am I free to actually have? Because, you know, when I come here now to law, on the hungry me, you can't pay me say I no study law. With all my time on campus, I just use it to, so why I call the talk for? You just to go to radio and go and read news? No, serious, those that know me actually know that I can talk. Am I not talking? No, serious, am I not talking? Now, are we not talking? We're just, I use all my time to toast woman, toast this one, toast this one, toast this one on campus. When I can use it to actually come to Faculty of Law and different background. What? Put your hands together for her. She says she has a different motive in mind. What? Are you in year 1? Year 3? And you're moving away from, let's face this thing now. Because you're the one that, she's going to represent Unilag soon. Let's see, I'm going to endorsing her. Ladies and gentlemen, put your hands together for her, please. And now we'll be doing, not Nigeria, we'll be doing African tour. And now our first country will be South Africa. So please get her a topic in mind. Let her go and be rehearsing. But what do you have in mind this afternoon to share with us? Put your hands together for her. I love bringing people. No, don't do like, they don't tell me no. As you see, they do this whole style, what they do for you, like, for you. Put your hands together for her. Just say something on what you learned today. Don't just say anything. What you learned from here today. Put your hands together for her. I don't have to drag you, but I need to actually get comments from people, and I need comment. I'm still going to bring you up. So let me not bring you out. What did you learn?
Just been here today, open my eyes to what actually entails data protection. The fact that things, the fact that it's very easy to breach a person's privacy and
You say being here, panels, that being here expose our eye, open our eye to another different thing. I'm going to go around. I need you to hear your voice. When I say, okay, what did you learn from here today?
I learned that you can have a bad case, but if you know the law, it might work for you.
Then she deserve a round of applause. So, okay, they come meet you. And bless me and this guy, we go Sabi talk where. Oh, how are you? How are you? Yeah. He laughs and don't pursue me. How are you? What's your name? Oluwalashe. What did you learn today?
I learned that there are multiple. Again, guys.
I don't, you know, is Oluwalashe shy? I don't understand. I learned oh, it's the Holy Ghost. It's not Holy Ghost we're talking about here. No, it's not in Holy Ghost. I keep hearing, I don't know whether it's only me hearing this. That's why I say you should use your mind.
So I think that there are multiple provisions in the law that are protecting like data privacy, because in this modern age, data is actually one of the most important aspects of an individual. Your data, protection of your data, the privacy of your data.
Now, we they always do this kind of style when we did secondary school. When they read the time where they walk on us, and now you place that they go. Now, yeah, I will go give microphone next after Tolu Alashe. In the one they come out the row. Now, one for them, put your hands together for them, for they are going to prepare their question for us. They say, oh, yeah, follow us, talk.
So, yeah, like privacy of an individual is a very important right of the individual. So, protection of that person's privacy should be like the focus of the law, the primary focus of the law.
Wow, you see, the privacy of an individual or the data is worthy of being protected. How are you? You just they go. You know, far back then, we will know they try come out anyhow. The way we take come out, say lecturer no go hold us. See me, we be say I call like this later. If you be saying like this, I go take come out. When I go like this now, lecturer, just leave him to go. Just are you going on time or what? Put your hands together for this 2 men. They're going to tell us. What do you learn? Don't be sad, do it intentionally before you go arrange me for outside. How are you?
I'm fine.
Hope you have fun here today.
Yeah, I'm trying.
My name is Solid Malam. What's your name?
Gabriel.
Gabriel, what do we learn here? We're just doing, okay, let's just get this data protection and other things that were the panel and what they call the put scrutinize and actually ask themselves a question. But I don't know. Did you learn anything today?
Yeah, I just learned from their courage and their charisma.
Give that voice Belen now. I like with voice. Without your courage, we take come out now. Every voice going to slow like this. Oh yeah, talk to me.
I said I learned something from their courage.
Their courage and charisma and the way they debate the point. Does he deserve a round of applause? Put your hands together for him. Ogami, Chukudi. Yeah. If I didn't say, I wouldn't to you. Oh, let's talk to me, dear. Okay, let's just get from you, Damilola. What did you learn?
I think I know about data protection and how citizens' rights can be infringed upon by the government trying to like gather some details about them that's personal to them and some limitations that are attached to it, and the need to have some of this information for security and to help reduce the crime rate and all of that. So yeah, that's what I learned.
Wow, help to reduce the crime rate. Does it deserve a round of applause? Please celebrate him. God bless you. Now you can now go. Even though you don't go like this, you can go now like this. You can go like this now. Okay, put your hands together for them as they're leaving. How are you? I love the way you're clapping. You've been clapping since. So let others clap for. Please, ladies and gentlemen, shall be the one clapping since. The brain behind Papa, you're hearing, she's the one. And I want please a round of applause for her. She has been clapping for a lot of people and she deserves a clapping offering. Are you there? How are you?
Fit.
You're going to do like say faith no day again. Faith, connect that faith with us now. They like your faith, they like Wi-Fi. With the all left right today. How are you? Babe, how far you don't go? About baby. Okay, bounce, I know the real. Hey, Faith, talk to me now.
So basically I learned that our right to privacy
Appreciate everyone here present. I believe from the reaction and from the question and ask, I believe coming here, you didn't just come in vain. And I must encourage you guys, please, everywhere you find available seminar or things, go there, grab something. Do you know why I'm happy? I'm happy because you've learned something today. And at this moment, ladies and gentlemen, we're going to be going to the panel as to take their feedback. God bless.
All right. All right. Thank you very much, Educated Malam. So it's time for the feedback from the bench, from our panel of eminent justices of the ECOWAS Court.
Maybe take from the
online.
Yes, virtual judges.
Oh, thank you very much, Your Excellencies, and to the organizers. Let me first appreciate this initiative. In fact, I just had a discussion with my my boss, the National Commissioner, and my impression was that if these guys were lawyers, we really don't have to look too far in, in whom to employ, as the case may be. So please, we are looking out for you at any time that you are free. Let us interact more and see what can be done. All of you did excellently well. And that is why the decision could go either way. And I didn't want to, for that reason, come in to speak as a regulator, whereby the judges in-house who examine the comportments and all of that will now be prejudiced to one way or the other. So having said that, in fact, you have given enough materials for me I was actually writing opinion, and I couldn't exhaust all I wanted to say or to put down. But there are about maybe 4 or 5 areas that we actually need to look at quite closely. And the first, to start from the simpler ones, that's the copyright, the issue of copyright. Even from my practice as a private lawyer, I still struggle to understand the basis of a copyright under a human rights claim, unless it's an ancillary claim. Of course, sometimes this copyright issue may be properly described even as a human right, but immediately you begin to refer to it as a copyright. Then, of course, the enforcement procedure to adopt will be different from human rights enforcement procedure, and then the jurisdiction of the court, how to invoke the jurisdiction of the court, will also be different in that regard. Again, on the independence of the court, and that's another serious, the independence of the commission. This court has actually decided in the case of incorporated trustees of the Digital Rights Lawyers Initiative and the Federal Republic of Nigeria, is a recent case, 2023, that NITDA, which is even not a properly constituted data protection authority implementing the NDPA then, was recognized as being independent on the ground that the NITDA doesn't refer, or did not, as then was, did not refer, had no reason to refer its decisions to other people. But the fact that an administrative authority is under a minister or under the president and all those provisions cited doesn't make it less independent. And that is the decision of this court, the community court, in that regard. Then the technical and organizational measures, when one of the agents, I think for the respondents, said that encryption, based on the provisions of Section 39, that encryption will suffice as one of the measures to be adopted. You have to take into consideration, as a matter of fact, if you look properly at the provisions again, you will realize that it goes beyond encryption. There are so many other technical and organizational measures, and they have to be adequate. And are they adequate? Then again, you look at the principles rightly cited by the applicants. You look at the section 24, you look at subsection 2, of that, and even 3, paragraph F of that section 24, which talks about confidentiality, availability, and confidentiality, integrity, and availability of data. And again, section 24, subsection 3 talks about duty of care. And then when you talk about duty of care, then there is a standard of care that is expected of you. You have to demonstrate all of this by the series of measures that you have put in place. Now, to more fundamental issues of jurisprudence, the lawful basis of data protection, the lawful basis of of data processing. That is, what can the applicants, or what can a data controller rely on? Of course, I won't bore you with all of that, but it appears the respondents are relying on public interest. And then I asked the question around necessity or necessary. If you look at that, you look at the requirements of the provisions of the law, the NDP, it refers to the Constitution, particularly, and the derogations permitted. This has to be funded. It is important that when an applicant is making a case, you have to take into consideration, or when a data controller intends to rely on any provision of the law to process personal data, particularly in this context, where derogation seems to be the case. You are derogating from the norm, but that derogation must be necessary. That has been decided what is necessary. Of course, rightly answer that of course there is no other measure, there is no other way. But then there is what you also call proportionality. The methods adopted, is it proportionate to the risk? Is it proportionate to what is envisaged? There is nothing in the arguments from the respondents that says that the measures adopted is actually proportionate. We have seen a plethora of cases from the European Union jurisdiction in this regard. It is not just the case that you have to, once the president has directed, or once the NSC is the one, or you have cited, in fact, the provisions of other laws regarding data regarding data processing, especially if it is for counter-terrorism, money laundering, or counter-proliferation, and all of those, then you could be said to be right. That is not always the case. There must be a limit to that. And the principle that applies is the principle of proportionality. You may have to look at the provisional section, I think 45, in that regard, under the 1999 Constitution, that is, for a limit to what can be done. It has to be properly provided for in a law, and it must be justified in a democratic society. That is also very important. And again, there is a provision under the NDPA, that's section 63, that talks about the primacy of the act. So if any provision of any other law is in conflict with the provisions of the NDP Act, as far as that provision of that law relates to personal data processing, the provisions of the NDP Act prevail. So at no point should any law in Nigeria today make provision for the processing of personal data in a manner that violates the principles set out under the Act. Now, talking about adequacy of data protection, adequacy in other jurisdictions, of course, it is correct to argue that you don't need, it is not always the case that it is adequacy, that the other jurisdiction must be adequate, but there are other provisions that must be put in place. And interestingly, just I think maybe last month or this month, we got a judgment of the court which actually invalidated the whitelist, some names or some countries on the whitelist on the ground that they were not included. The measures adopted for their inclusion, or the metrics of the adoption, were not proper, even by the standard of NDPR, not even the NDP, by the standard of the NDPR. So it is not only the law, not only the existence of the law in a country. There must be an existence of the law, independent data protection authority must be in place. The enforceability of data subjects' rights. So you have a country, probably maybe let's say Niger, for instance, which has all of this, but Niger is under a military regime now. And would you therefore say that you have appropriate mechanism in place? So it is important that in making an adequacy decision, you look at the entire framework, not just one of the metrics to determine whether a country is adequate. And if there is no adequacy, then of course you can now go back to Section 43 and look at other measures that you can rely on. In this case, the public interest, which is important, but then the public interest, you cannot read it in isolation of the principles. You must have fulfilled all other conditions that enables you to collect the data in the first instance in terms of public interest before you can even say you are transferring that data abroad. Well, I think maybe for want of time, let me stop there. But let me mention also that the NDPR, I like that argument from the agents on the NDPR. The NDPR does not supersede the NDPA, even though the NDPA preserves the NDPR. It only preserves the NDPR to the extent that the NDPR is not in conflict with the NDPA. So if you are relying on any provision of the NDPR, which is in conflict with the provision of the NDPA, the provision of the NDPR, it would be null to the extent of its inconsistency with the NDPA. So, my Lord and Your Excellencies, distinguished ladies and gentlemen, I sincerely appreciate the contribution and the participation of the contestants. And we look forward, in fact, to engaging with them in the days ahead. Thank you.
Sorry, I can't hear. Can you hear me?
I can hear you.
Okay, I can't hear. I can't hear from
the platform.
Your closing comment on the agent.
Now I can hear you. Thank you very much. In fact, a lot of what I wanted to say has already been echoed by Mr. Bamboy. I was really, what word do I use? I don't know what word to use. Impressed by the quality of both sides. Like he said, I'm sure even if we had if this was like a real court, we probably will not have necessarily this quality of arguments from both sides. In my opinion, well researched, and there was like a really keen eye for details in terms of the memorials and also how they were spoken to. Again, a lot of the things I wanted to pull out have already been pulled out by Mr. Bangwe from the NDPC. But maybe three things I would like to emphasize. The first one was on the issue of legal basis versus principles of processing. I think there are clear distinctions between the two. And although I think of the memorials probably for the applicants covered both, in speaking to them, it wasn't quite clear. It seemed like they were conflated. And one clear distinction is that whilst you must have all the principles adhered to at every given time, you have to adhere to fairness, transparency, and all of those things. For the legal basis, you can rely on only one of them at a particular given time, or you might have multiple, right? And so I think not being able to distinguish that, in the course of the argument was a bit confusing. It seemed to conflate both together. So that would be my advice to say, to be able to clearly distinguish between those, because they are extremely, extremely important in terms of how one deals with processing of personal data. So that's the first thing. The other thing I found interesting was the issue of independence. I think there are very many ways of proving independence or otherwise. And it was quite interesting to speak about the fact that the members of the commission were appointed by the president, based on nomination by the minister. I'm not sure if there's any data protection authority anywhere, at least in Africa, that is not appointed by the president, right? So I'm not sure what would have been the expectation there. In terms of nomination, I know different countries have different ways, but what we have in Nigeria is probably what obtains in most places. In some cases, though, like in South Africa, you have like an open nomination process, and the nominees are interviewed by Parliament. It's very open and it's participatory, So I wasn't quite convinced that the fact of the nomination and appointment was necessarily an issue of independence. There are other areas I thought we could have looked at in terms of like composition, for example, sort of drive home the point around independence that did not actually happen. So that's just my comment on that there were probably other areas that we could have considered in terms of independence. I see you holding the mic. I think you want to stop me, or do I say the last thing I wanted to say?
Oh, you may proceed, yes.
Okay. And I already mentioned this in the question I asked about I think it was around local standard or the argument around the extension of local remedies, and focusing only on it being customary international law. I wanted to just emphasize that customary international law, yes, is definitely one of the sources, but at the end of the day, it's really based on the consent of states, right? And so it's not like it's cast in stone. It seemed to be like the position was that it's cast in stone. Once it's there, then you must apply, which I don't think is actually accurate. There are exceptions and there are ways you can sort of explain it away, but I don't think enough work was put into trying to sort of have cogent arguments or reason behind, not following what the court has done previously. If you want the court to overrule itself, I think it's just common sense. You really have to go to task and show them why either they've been wrong previously or this particular instance is so different from what they've faced before that they actually have to rule otherwise. So those are the three high-level things I wanted to share. Thank you very much.
Thank you very much. A round of applause. Yeah, good talk. Any other from the judges here? Yes.
Okay, thank you. Generally, I would like to let all the agents know that you've really done well. However, for the respondent, I think for the second agent from the respondent, so based on what one of the online comment the panelist mentioned, so on the issue of encryption, you don't necessarily have to confine yourself with what you have in your memorials or statement of facts or whatever. So you could actually explore further because it is allowed, even though it was mentioned in the beginning of the sessions. And then also, I would also like to acknowledge your the way you've responded to some of the points, especially some of the questions that were raised, especially bringing the real life scenarios of the NIMSI situation into answering one of the questions. That was actually a good one. Also, your other colleague also, though the case is quite tough for you guys, but based on your response and the way you have also point out and also like to defend it, it was a good one. Then for the applicant generally, yes, they did a lot of work and also try to make you guys not to be able to defend it, but it was a favorable case for them, but they also did a lot of work to also make it more difficult for you. So good one from them generally. Thank you.
Okay, so I think before I speak to my feedback, generally I would like to say well done to the team, both on the applicant side and on the respondent side. I think you demonstrated in-depth understanding of the subject matter that has been brought before this honorable courts. Your confidence, your tenacity, your courage, and even your understanding of the legal principles. I mean, it was actually top-notch, and I want to commend you all of you for that. So in terms of specific feedback, I will start with the applicant. Now, with respect to the legal basis and the principle, under the ECOWAS Convention, ECOWAS Supplementary Act, I think you only relied heavily on legality. So there was no reference to necessity and proportionality. And the reason why that is very important is because if you go back to your fact pattern, you will realize that there was an objective in terms of what the federal government intended to achieve by giving that directive. And that objective is actually with respect to harmonization of the databases of the MDA. That is the objective. Now, the question is, by reference to mining social data, how does it advance that objective? So I expected you to have perhaps dwell more on the necessity and proportionality points in terms of demonstrating to these courts how the mining of private data from social media will advance, or is even necessary in terms of advancing the objective of the federal government in the first instance, right? Because for me, that is core or is key to even the other issues that you highlighted in the course of your analysis. Now, the other point is that in terms of the domestic law, we relied heavily on other principles, but there was another fundamental principle that you also did not explain or that you didn't mention at all. If you recall what one of my colleagues mentioned earlier, in terms of the principles, they are cumulative, they are conjunctive. So your satisfaction of one principle does not in any way insulate you from other principles. So you must demonstrate compliance with all the principles. Now, one principle that you did not examine is accuracy. Mining data from social media, how do you reflect or how do you demonstrate to the courts that information gathered from social media is actually reliable and accurate? Somebody may put Celestina forward as a male on social media, right? You may type Celestina Nwabueze and you just see Celestina is a male, which is not accurate. It's not a true reflection of who I am. But at the end of the day, how do you begin to demonstrate reliance on information that is not even accurate in the first instance? So I expected that you would have come through the principle. I understand that you don't have time, but I actually expected that you would have come through the principle. In the course of your analysis is accountability. But what you fail to demonstrate before this honorable court is to link it up with applicable facts or to demonstrate how the respondents indeed failed in the obligation to be accountable to some of the principles that we have under the Data Protection Act. And I will give you a good example. You didn't make any allusion as to whether there's an impact assessment that was done in the first instance. So bringing up or deploying AI is very significant and has a high threshold of impacting the rights and freedom of data subjects. And one of the accountability measures, or how you begin to demonstrate accountability or operationalize that provision that speaks to accountability, is to demonstrate that you did an impact assessment, right? But that was never done. The fact pattern didn't demonstrate that there was an impact assessment. So I needed you to have dwell on that fact just to demonstrate that they've not actually complied with the provisions of the Act. Now, with respect to copyrights, I think Babantunde actually mentioned that in terms of giving you guidance on how you should have dealt with this separately. But I think when he also gave you the indication, when he asked you some questions and he wanted you to provide clarification on why you think that the infringement of your copyrights is a matter that should be adjudicated before this court, I needed you to have relied on the response that he just gave, which is ancillary claim and principal relief, right? So you would have adduced evidence or explained to this honorable court that the copyright infringement is actually an ancillary claim, and even though assuming without conceding that the court doesn't have subject matter jurisdiction, to the extent there is an ancillary claim, the court will not discountenance the claim with respect to other reliefs or the claim with respect to ancillary and the ancillary claim in relation to what has been brought before the court. And then you lace that with cases on that point. Now, with respect to the transfer of data to other countries, I think I didn't really understand your explanation when you talked about Gambia being subject to a law, because apparently you did not take into cognizance that that provision has some subscription to it. So it's circumscribed to other safeguards, right? So it's not just being subject to a law, but it's a law that affords adequate level of protection with respect to personal data. So I asked specific question regarding that, and I expected that you would have been able to explain or clarify that provision, but that didn't necessarily come out. Now, the other point is also closely related to what Babantunde mentioned earlier. I also expected you to even start with the NDPR, right? The whitelist, because they commented on that Gambia has been designated as an adequate country by the commission, right? So on that basis, if the commission actually takes or took the discretion, okay, to a determination that Gambia is adequate, then ordinarily to a layman that doesn't understand the tenets of data protection or that doesn't understand the legal development in terms of the recent case on this point, you would have come to a determination that why are we still debating it if the commission has indeed designated Gambia as a country with adequate level of protection. So I expected in your rebuttal for you to address that, right? But that didn't come out. So most times I think it's not necessarily the accuracy of some of these things, but the thought pattern, right, in terms of your responses to some of the issues that your other part or the counterparty decide to raise in the course of the analysis. So I expected you to have raised the recent case on adequacy, and even take it a step further. I also expected you, for want of debate or whatever it is, to even demonstrate to this court that reliance cannot be made on the whitelist, that reliance should not be placed on the whitelist. Reason being that NDPR is actually a previous law. So the Data Protection Act is the later in time law. Even though it says that it preserves the NDPR, I expected you to have demonstrated that perhaps there is a conflict between the mechanism under the whitelist and the present conditions for designating a country as being adequate. Because I would imagine that if the commission wants to revisit that list, for all you know, maybe Gambia may not be in that list anymore, right? So I expected you to have demonstrated that in the course of your analysis. I think, so that is with respect to the first team that spoke on the applicant side. Now, with respect to the second agent on the applicant side, so I think there are heavy reliance on lawful basis for collection of personal data. And you also talked about erasure as one of the rights that you have, and you didn't demonstrate to the courts that ordinarily, I know it's not contained in your fact pattern, but I asked you questions specifically on whether that right to erasure can be applied, right? Because the facts that you have before this court only speaks to the data portability. So I needed you to demonstrate that, fine, it cannot be implied, you're required to exercise this right specifically, but in terms of what the law specifically says as it relates to data portability and the essence of it. So if I'm saying that you should move my data to another data controller, right? On what basis would you continue to retain that data if you don't have any other lawful basis to continue the retention of that data? So we can always have an argument around it, whether if you don't have any lawful basis, can you continue to retain that data? Or if you have, or do you automatically, or should you automatically delete that data because you don't have lawful basis to continue to retain that data, right? But that analysis did not really come out. I understand that it's not in the fact pattern, but to the extent that that was an excuse or justification for not transferring the data to another data controller, I think it should have been pertinent that you try to debunk that justification, right? Based on the parameters of what we have under the law. Also, the other point is in relation to, sorry, I'm just trying to go through my notes. Okay, so the other point is in relation to some of the conditions precedent with respect to, or what should happen in the event of a breach. So there was an interception. So you only demonstrated that no notice was issued to the commission, right? When there was an interception, and that amounts to a breach. But you also did not demonstrate to this court that there was no notice that was issued to you as well as the data subject, right? Because it's actually two layered. So it's not just notice to the commission, you also have to issue a notice to the data subjects alongside. Once there is a likelihood of once there's a high risk to the freedom and rights of the data subjects. So that didn't really come out. Okay. So on the respondent side, so I will start with the preliminary objection. I'll start with the preliminary objection, and perhaps flowing from my comments or my feedback on the applicant side, what I expected you to have done with respect to the preliminary objection is also to immediately demonstrate to the court that the relief with respect to infringement of copyrights is not one that should be determined by the courts, right? And you already talked about the ECOWAS protocol that clearly sets out the parameters for determining when the ECOWAS courts will indeed have jurisdiction to determine a particular matter. And issues of copyright doesn't appear to be one of it, particularly when you take into account that the copyright framework, legal framework, is actually domestic law, right? So I expected you to immediately discountenance that relief or that particular issue that was brought before the court in terms of putting before this court or urging this court to discountenance reliefs with respect to infringement of copyright. But that didn't really come out. So the second point, okay, the second point is actually with respect to some of the principles. So you relied heavily on the fact that even though the law says the processing of personal data must be specific and well-defined, right? That there is nothing in the law that empowers the president to issue that directive or that indeed foregrounds the collection of that data that speaks to specificity in terms of what should be done. I wasn't really convinced in terms of that argument, particularly when you take into cognizance of the fact that the Data Protection Act has a supremacy provision, right? So if you have a supremacy provision, that means whatever law that you're relying on to indeed sustain that argument will hold no water in the face of the supremacy provisions that we have under the Data Protection Act. So I also needed you to have addressed that issue when you raised it, because that was a loophole in the argument which you didn't take advantage of. So finally, with respect to the second respondent, I think my only comment is your reliance on the whitelist. So you relied heavily on the whitelist, but most times when you're putting forward an argument of this nature, you should also take into cognizance, you should be able to preempt, particularly because they don't have a right of rebuttal, preempt the possible response that would come from the respondent. Just imagine the respondents coming up with issues of inconsistency, coming up with the recent decisions. Then literally that means if I'm actually persuaded to go with the arguments, at the end of the day, I'm not going to give you any credits for your submissions on the whitelist. So I expected you to have layered your arguments. So come up with alternative arguments, try to convince me on other safeguards, because it's not just adequacy principle that you have, right? There are other safeguards that you would have relied on, not just the adequacy. So you would have layered your arguments in the alternative. That is assuming the argument on adequacy fails. So what other arguments could you possibly use to convince this court that you have the adequate legal principle to indeed make your cross-border transfer? So I expected that to have been done when you made submissions on the principle of adequacy or to sustain your cross-border transfer. I think generally those are my comments. Well done once again.
Yes. Well, let me quickly say that last year we had one senior advocate after the program. Today we have 4. You should give yourself a round of applause because you've done so excellently well. The submission from the first speaker, you first agent for the applicant, you anticipated the response, and starting from where she finished, you anticipated the response of the counterparty, the respondent. When you do that in legal submission, you block you've already anticipated. You give the judex an impression that you understand it, and the judex will rely more on what you have said, because you have said what you want to say and what the other party may come to say. It's a brilliant way to put submissions before the court. And the moment the judex takes you seriously and takes your submissions as true, then it's difficult to listen to the counterparty. So it was the excellent way, good start for you. But these days, the use of Latin maxims is not as fashionable as it used to be, particularly because simplicity is always very significant. So let the points drive in easily and in a simple fashion. Regarding the second speaker, you also give responses to the questions we asked, also a brilliant submission from you. And I also am pleased with the way you have articulated your issues. The counterparty, the respondents didn't do that quite well, but you started with issue 1, 2, 3. Now, every legal argument starts with an issue, it starts with a conclusion. You close issue 1, you close issue 2, you close issue 3. The judex will form a view. Have you been able to convince the judex on issue 1 based on the facts and the law? Issue 2, and every point you have to get your score. At the end of the day, you look at the 2, 3 issues. The second agent also continued. Issues 4, 5, and 6. Lawyers find it difficult to do this because they run around arguments, but you have been able to tailor your submissions to those 6 key issues. You reach the resolution on all those issues. There is no way any judex would not make a findings on those issues because you have urged me to find on the issues you have raised. Submissions, I'm sure they taught you IRAC, issue, rules, application, conclusion, even though it's not cast in stone. But the way you have identified them, you have followed the rule and the template excellently well. So I appreciate the submissions you have made and you've done well. Regarding the second respondent, I mean, I like the first agent for the second respondent. You tried to, you simplified the cases and you embellished it with the law. That's also an excellent way by using precedent. Yeah, and you're also very bold to ask the court to depart from his earlier decision. Now, a lot of lawyers, even in practice, don't even understand this. They try to hide away from the earlier decision, not thinking that the court will find it. You must identify them. This court has held in this decision on this principle of law. We think that they were wrongly decided. This is our view, or we think that had they considered other points, and that was why I asked that question, they would have decided this way. You must be bold because research these days is very easy. You have Law Pavilion and other research tools. And so there's no case a court would have decided that is not everywhere. And so if you come clean and say in these 4 decisions, the court decided this way, and I want you to depart, but you must always have a reason. 1, it was wrongly decided. Or at this law that existed at that time, it would have been decided this way. Thirdly, at these facts existed, been placed before the court, you would have decided it this other way. And that's an excellent approach. And the moment you put that, I don't need to do much of research. You've given me all the other cases the court has given in the past, and you have given me your own position. So you come there, but some lawyers these days try to hide from those decisions, which is, rules of professional conduct also is against it. If you know there is a decision that is against your point, you must present it. The last respondent, the second agent for the respondent, some of the facts presented by all of the parties, it's sometimes you need to process the information, but the best advocates are those who put the point in a simple fashion that everybody would understand. And so I understood your points, the way you narrated the point in 3 folds, and you gave the responses to them. Then you also made another one in 2 folds, and you gave responses to them. That way, when you are making your closing submissions or any submissions at all, it's not a place to hide. It's a place to come up with all of the facts and address them. You did that excellently well in your closing submission. And that way, and I told the other judges that, well, I now understand it clearly. And, any court proceedings, more and more these days, it's important the public understand what you say. And even for the judex that write decisions, you are writing for the public. You are not writing for yourself, you are writing an opinion. That opinion must be understood. If it is not understood or the listener does not understand it, you've said nothing. And so that is a very excellent way you have put the point. You also made the respondents call, even though, as one of the judges rightly said, you didn't have a good case, but you presented a good defense. And I also very like the fact that if the law is the law, I mean, one of the questions, you said that's the law. If that's the provision of the law, then that's the provision of the law. And so that was also a good defense. In all, all the agents have done excellently well. We would like you to appear in courts and give these submissions. And also, I think some of you said, I argue, but a final word to use is I submit. You submit. that way it puts the point, you are making an argument already, but if you submit, you are submitting on that argument. So some of those words, you know, the right one to use. Overall, you've done well, and I must appreciate all your submissions.
My Lord.
I don't have the power to confer you with the rank of senior advocate, but by the grace of God, you shall all be senior advocates one day.
But, my Lord.
Go ahead, sir.
That before you make the final remark, may I add, I don't want to speak after you must have concluded. Sorry for interrupting. But I would like to say that I believe very strongly that the decision of the judges is not based on whether a case was bad or good. It was based, it is based solely on the presentation by the applicant. So none of them should go away thinking that, oh, probably we could have won if we had a better case. I think it is good for the agents on either side to understand that it is not about the facts that we give you victory, but the merit of your own arguments, simplicity. That is what will give you victory at the end of the day. So thank you, Your Excellencies.
A round of applause. All right. I mean, you have come to that very moment that we all have been waiting for. And I'm sure everybody is expectant, especially the contestants. This man, his face is very, very strong. But I want you to relax and drink some more water. Okay, so we have 5 different categories of prizes and awards for this competition. We have the masters of the Moot, who, of course, are the overall winner. We have the second runners-up, and we have the first runners, and then we have the second runners-up. After that, we have award for the best memorial, the best memorials award. Like I said earlier, the memorial have been previously assessed and graded, and a particular team has emerged winner in that regard. They will be given the award. Also, we have the award for the distinguished advocate, that's the best oralist of this competition. That's the essence of asking the judges to score the participants, the contestants, the agents individually, so that we can collate their results and award them appropriately. Like I said, we have come to that moment of decision that we all have been waiting for. Of course, I said that we are not going to unveil, we are not going to leave the veil of the identity of the teams until the final moment. But now the competition is concluded, you can safely lift the veil of the teams. To my right, we have Team 16 from the University of Lagos. The University of First Choice and the nation's pride. Great Akokais. Greatest Akokais. Greatest of the greatest of the greatest of the greatest Akokais. You people are not Akokais too. Greatest Akokais. Now you are talking. Team 22. All the way from the Obafemi Awolowo University, Ile-Ife. Please stand up and take a bow. Represented by the duo of Oluduro. They appeared representing the applicant in this matter. And then, like I said, we have Adedayo Michael and Tiwalade Adekile representing the respondents who are from the University of Lagos. Then we have another team in the house who also scaled the semi-finals and are here. Team 25 from the University of Ilorin, Kwara State. They also have done very, very well. We have other teams that we probably won't mention here now, but we thank all of them. Some came from Benin, from Enugu State University. We even had 2 private universities participating, but unfortunately they dropped out during the preliminaries. But it was a good thing. We didn't have any private university participation last year, but 2 of them participated this year, and that's a good thing for us. Okay, now to the matter that concern Matthias. From my score here, the respondent team representing the University of Lagos had a cumulative score in the aggregate of 84 points. Where is this guy? Fear has caught him. He ran away. We have to wait for him. Because I know, yes, because I know that in court, if a defendant is accused of an offense and he refuses to show, my lord, enlighten me if I'm wrong, that case will not go on that day. The court will ask that he go and be produced. He must face his trial in person. So this man must face his trial in person. So we will step down this matter until he comes. So we'll proceed to the other matters. The best memorial awards. Okay, sir. I was saying that we are not going to shave your head in your absence. But now that you are here, you can safely shave your head. All right. I will repeat what I said. From the scores that the judges have given me, the respondent side, University of Lagos, has a total score of 84 points. And the applicant team from the Obafemi Awolowo University, Ile-Ife,
I think we'll go for commercial break.
has a total score of 87 points.
Put the hands together for them. Cool.
Stand up and take a bow. Congratulations, guys. They have come to the University of Lagos and beat us. Anyway, no big deal. Last year, we also won. So they are taking the trophy away to Ile-Ife. Hopefully next year, you come again and we'll see how it goes. Congratulations to Obafemi Awolowo University. They are the masters of the moot for this year. Consequently, the first runner-up is the team from the University of Lagos, the respondent team. Take a bow. The second runner-up is the team from the University of Ilorin. Now, So the best memorial award goes to University of Lagos. They had the total score of 132.3 that time. Now to the last prize, the Distinguished Advocate Award. I mean, contestants came in and came out of contention. But as at the last count, we had 3 contestants who are battling for the prize. At third position, we have Mr. Samuel Oluduro with a total score of 381 points. In the second place, we have Adekile Tiwalade with a total score of 409 points. And for the Distinguished Advocates, we have the delectable, popular, and inspirational advocate, Mr. Inioluwa Olaposi. Inioluwa Olaposi, with a total score of 227 points. Congratulations, guys. You have done very, very well. So I will now invite Milord Oshodi to present the prizes to the winners.
That's
Yes. Congrats, guys. Well done. Well done. First runner up, University of Lagos. Come forward, please. Our guys, be happy for them now. Congratulations. Second runner up, University of Ilorin. Be happy for them. Be happy for them. Well done, well done. Congratulations. Best Memorials Award, University of Lagos. And Distinguished Advocates. No, from the front. This year, Meta has been very, very gracious and has decided to give to the winners of this particular competition a whopping sum of 350,000 naira prize. Congratulations, guys. Congrats. No, except from the front. The first runner-up goes away with very delicious sum of 300,000 naira. Second runner-up, Abi. You guys must share the gala. Don't go and eat that money alone. Second runner-up, 250,000 naira. I was being told yesterday by your coach, Unilag, that you now have the money to go to the African court, African Moot Court. Congratulations. And the best memorials award, they go away with 100,000 naira. Guys, you see why they must share the gala? Distinguished advocate, a handsome sum of 100,000 naira. Congratulations, congratulations, congratulations. Okay, so there will be a group photograph with the judges now and the contestants. Our own DVC, Development Services, Professor Ayodele Asemola is now. He was around in the morning. She said again, so she also joined us. Probably want to say one or two things before we. Just congratulate the teams.
Well, once again,
let me introduce her properly. She's not only the Deputy Vice Chancellor of Development Services, she's also the team lead of this project on National Data Protection Moot Court competition.
thank you very much. I think since yesterday, I have been expressing my delight at the fact that this particular project out of our entire data protection project is really gaining traction. And I can just hope that we can continue to build on what it is that we have done. Akin, we had how many competitors this year from the very, we actually had 17 university teams, put in, and we would have had 4 teams here, but unfortunately, one of the teams could not join us yesterday because their university exams are scheduled for now. I am sharing this because I'm hoping to enthuse some others that it can only get better. And I can assure you that we'll do better than 350,000 even next year. So if you know what's good for you, get on the bandwagon. But I hope this has been a very positive experience for our various teams, the members, the competitors. I hope that you have gained much. And even if you do not make a career around data protection itself, you have become very knowledgeable as to be able to make impactful contributions. I am sure the judges will be able to highlight for us some of the arguments you've advanced to push the jurisprudence. And those will be things that we also want to showcase. And we will possibly be looking at having, we have a journal, we have an e-journal. It's an online journal, and it's published by the Pretoria University Law published for this. So if you have articles, academic articles, that can significantly contribute to the development of knowledge around this, you're welcome from the lessons that you have learned. We thank you very much. Congratulations. And I want to say a very big thank you to our judges, those who have been with us ever. Some were with us last year. They're here again. And oh, Lolade is still online? Okay,
Yeah.
thank you very much. That is Lolade. Can you please show your face? I thought I had her voice. Yeah. Okay, well, while we're waiting for Lolade to join, Lolade is the program manager that enables us to be able to get the funding from Meta to do this project. And we're in the 3rd year of the project, the 2nd year of the competition. Lolade, we're deeply grateful for NITDA that is always right beside us. We're deeply grateful. And to the audience who have come to learn, to share, I say thank you very much.
Let me also join. They don't put me outside of
That's Lolade behind us. So see if you can. Lolade, it's just that you have a dot of light on your face.
Sorry, I have a what?
Light on your
reflection.
Oh, light from behind. There's light coming, so you can't see me properly. Let me try and change the direction. Is it better now?
A bit better.
Let me just try and change my position.
Fantastic. Bangboye, Babatunde. Thank you very much, sir.
Thank you very much, sir.
All right, thank you very much, Prof. Thank you, judges and the contestant. Okay, so, I mean, this brings the competition, to a close. But before we go, okay, so anyway, yes. I'd like to sincerely thank our judges, Mr. Rahman Oshodi. A round of applause. He's always with us. Whenever we call him, he's always obliging. And sometimes you even remind me, when is that your competition again? That's how he is. Please, appreciate him with a round of applause, please. Thank you very much, sir. We are very grateful. I also want to thank Celestine Iwabwese. I mean, she just stepped out. She's always been supportive as well. When I called her to go the extra mile for us yesterday, she did not hesitate at all before she took on the challenge. Celestine, we are very grateful. God bless you. And also Mr. Sadiq Bello. This man is our longtime partner. You know, we have run two data protection courses in this project, and he's always been one of our facilitators. He's also one of the reviewers for our journal. He's also one of the judges for this Moot Court competition. A very robust round of applause for him, please. Thank you very much, sir. We are very, very grateful. Mr. Babatunde, our doctor, I already conferred him with a doctorate degree this morning. Yes, so Dr. Babatunde, God bless you. He has ably represented Dr. Vincent Olatunji, who also has been a long-time partner in this project. He's always coming around. Last year, he delivered the keynote address during our mini conference. Thank you very much, sir. Yes, and my friend, long-time friend in the jungle, my buddy in the jungle, like they say, Dr. Ololade Shilon. A round of applause, please. I mean, Meta is the reason why we are here. And the reason why Meta made it possible for us to be here is because of Ololade Shilon. She would have been here physically. She was present physically last year. I dragged her and dragged her and dragged her this year, but she wasn't able just to make it. I understand, and I really appreciate you. Thank you very much for your support. God bless you. A round of applause, please. Ololade, I will do this again next year. God bless you. You don't have to answer now. Thank you very much. So that will be the end of the proceedings for today. Lunch is ready. We'll serve lunch now, and then we can go to our different destinations. God bless you all. Thank you very much.